Hello, everybody. Princess Belly Rubs is here. Giving me the nose nudges because she wants her Blue Buffalo health bars. Here you go, baby. Not spoiled at all. Not a bit. Nope, neither is our little camouflage kitty over here. I'm gonna turn my messages and calls down because people like to message me when I'm live. Well, hi, baby girl. Oh, who's the bestest? Who deserves Blue Buffalo? You do. Hello, Mortimer Duke. The first to comment tonight. He's on top of his game, y'all. You look at that. Hello, Joey Bag of Donuts. Okay. I know. I gotta give you 3. Sucks having a dog that knows how to count. Hello, C-Rex. Hello, Manuel. Hello, Nana Laura, honey. Hello, Bill Crayer. Hello, Buzzy Pug. Look at that. I give her 3, and she instantly settles down. After the 3rd one, like she knows. She knows. That's all I'm getting. Oh, geez, y'all are talking sports. And we have a sports-themed case tonight. What have I done? You guys are talking a lot of stuff. A lot of sports. There we go. Hello, Eileen E. Carlin. Took me a minute to get to you. Got a bunch of chatty Cathy's over here. It's okay. I love it. It's what I live for. Hello, Fire Mother. Hello, Salty Buddha. Hello, Charlie. Hello, Spider-Man. Oh, I'm so excited for tonight. Guess what? In addition to the FTC Go Fight Fail case that we're going to play, hi, Billy. Oh, this is dangerous. I found a soft sit. Sure did. Billy, please don't attack her. Please. I am begging you. I will do anything. I will give you treats. Here, have some treats. Positive association, right? Here, you can have some too. Because I don't know which one of y'all starts it. It's brutal. It is brutal, and I don't want to be in the middle of it. For as much as Ava loves them, yeah. That's why I have the graphic design images of me riding a blue buffalo and Ava riding a blue buffalo. Hello, Jeanette Amani. So good to see you. I am wonderful. I am happy and excited. I'm thrilled to be here. I'm so happy to be with you guys. We're going to have so much fun. You think we had fun last night? Ooh, wait. Oh, you are so welcome here with us. Hello, Stacy. So good to have you. All right. Billy he's gotten his treats. He's hopefully given up the fight. We'll see. We'll see how this goes. The tail is telling me it's not over. It's not over yet. What do you think? What do you think, Tiny? You think Billy's gonna give up the fight? No way! This early? Right at the beginning? That's amazing! Oh, they're just in time to see the soft sit and everything else.
Sir, this is your motion. What do you have to add to it?
I'm wondering if you got those check stubs that I've entered in.
I didn't get any check stubs.
So
Oh yeah. Wait a minute. I did get some check stubs. Yes, you were the one that did have them. Yeah, I had a question on those because you got 2 support notices on each stub. So do you have more than one case?
yes, sir.
Okay, how many children do you have?
2.
Okay, this one and another one?
Yep.
Okay, because I was trying to figure out, I have a feeling that what's happening is they are maxed out on how much they can take out of your checks. The reason that you keep getting hauled in is because you're not paying the full amount of child support.
But at the time that they was taking the money out of my checks, they issued the warrants.
Right. If you owe $100 and they only collect 70, you're gaining $30 a month in arrears. And what's the arrears hit a month? Well, that's why I was asking, because the amount of child support that is are these weekly checks or monthly?
Weekly, sir.
Okay.
It's 440. It was receiving that, and at the time.
And how much did they say that you owe?
Just now, recently?
Yeah.
They said I was in arrears is 5,000.
Okay. Yeah, because I have a feeling that's what's happening. Now, you have the right to have this child support reviewed at this point in time. It's been 3 years since the last order, so it can be reviewed for you.
But my whole thing is, I wasn't paying because last year, April, they got a $5,000 check on my behalf.
From whom?
From an employer, from a settlement, which was from an employer.
Okay, and they confiscated all 5,000?
Yep, it was.
Okay, and that should have gone against any arrears. Now, their next question would be, are you sure they got it?
Child support?
No, the $5,000 check.
Child support got that $5,000 check.
Are you sure they got it?
Yes, I'm sure they got it.
Because what I would do if I were you is ask for an accounting of the case to make sure they got it. And accounting will give you a computer readout of every month that you owe and every payment that's been made. And they do it in writing. So if you write them and ask for an accounting of your child support, because some of this stuff will not be in the court file. The court file is a public file. So the court does not know how much your arrearage is unless they apply for a show cause. Okay.
Okay. And I haven't been paying recently because I was under the impression that the obligation is $445 a month.
Well, it looks like how have you not been paying? Are you not employed anymore?
I'm at work right now.
Okay, well, it's because the employer automatically takes it out.
Right. I just started this job, and
okay. Then you have to notify the front of the court what job you changed to, so that they can apply it to the appropriate because they issue an automatic income withholding order. Again, that does not go in the court file because it contains some very specific information about you, and you don't want that public information.
This is what I'm trying to say to you, sir.
Hmm?
They received $5,000 last
And I told you what to do to deal with that.
April.
Yeah.
I was under the impression covered the rest of the year. I did not know that they
they don't cover anything forward. They only cover things currently owed.
Right. Okay.
They can't hold money forward. If they have an overpayment within 48 hours, they will send you back a check for the overpayment.
Okay. Well, they still was in breach of contract.
There is no contract. This is the law. That's not a contract.
Is this
They're
Zoom
following-
just about child support?
Yeah. Sorry, Ms. Cry. That's what his motion's about.
And
So-
why did I have to join? I'm thinking this for
Well,
my
'cause,
motion.
You have a motion?
Yes, I do.
I have a motion for child support and an amended motion for child support. Those are the only motions before the court.
My motion wasn't about child support.
What was your motion about?
It was basically just for me trying to get his rights and stuff revoked. I did all this stuff.
We don't revoke rights in a parent in a family law case.
You should have been getting some paper. I did all this stuff last week.
That motion would be automatically denied because we do not revoke parental rights in a family law case. That has to be done in a neglect case.
In a what case?
An abuse neglect case.
So why did they have me filling out the papers?
I have no idea. I don't know what papers you filled out. I don't have them. Okay. So I'm sorry, I didn't know you had a motion. But I was going to ask for your input before we finish this. I'm just trying to deal with his issues on child support.
Okay.
He seems to be under a misapprehension that this is a contractual relationship, and it's not. It's a statutory relationship.
Okay.
The front of the court is following their statutory authority to collect child support on behalf of the child. So that's what's necessary, and they will automatically follow their rules and the statutes in doing so. The court tells them when or if child support should be reviewed. And again, I've informed you, sir, Mr. Miller, you have the right to ask for a child support review if that's what you're asking for. But yeah, if you're not paying support, they're going to be hauling you in to explain why you're not paying.
Well, I also was sick.
Okay, that's fine too. But again, you're going to have to explain why the payments weren't being made and why you owe.
Payments wasn't being made because I was under.
You're under a misapprehension, not an understanding. So that one I could tell you you're wrong on. So the best you can do is ask for an accounting to make sure that all money is accounted for and all payments are accounted for. Now, do you want this sent to the front of the court for a child support review?
I want this case closed and dismissed.
It's not going to be closed and it's not going to be dismissed.
So even though they were receiving the full monthly obligations, it's okay for them to.
If you owe, they're going to haul you in to find out why you're not paying the amount.
And we wasn't receiving I wasn't receiving no full amount.
Well, ma'am, part of this, you're not going to receive the full amount. You're on state aid. The reason that this case was brought, it was brought by the state of Michigan because of your state aid. When you're on state aid, the state mandates the child support be paid in accordance with the law, and then they confiscate portions of that child support to reimburse the state for what they're paying on behalf of the child.
Is this Admiralty Maritime Court law?
No, it's not Admiralty Maritime Court law. This is the state of Michigan. We are not in the middle of an ocean.
Because the flag in the back got a gold fringe on it.
Yeah, don't even do that bull. That's a bunch of bull.
You have
it is a United States. I don't know what you're receiving, ma'am, but this case was brought by the prosecutor's office on behalf of DHHS because of state aid involvement.
Oh, I don't receive anything. I haven't since
okay, well then once you stop that, then you should be receiving the full amount, but the state will confiscate part of anything that's still owed to them from any child support collected. Right now, I'm not sure how much the arrearage is. Obviously, there is an arrearage. So, no, the UCC, the Uniform Commercial Code, does not apply to this court, sir. This is a family law court.
That you don't have on the gown neither, so you're.
Aw, the referee's familiar with these subsidiots.
Yeah, you're right. That's because I'm an appointed judicial official, not an elected judicial official.
So
yes, I have a full authority. I am sworn in. I am an attorney prior to being in my judicial capacity. So yeah, I have full authority, and the authority is given to me by statute as well. So I follow the statutes, the laws that I have to follow.
So this statutes and codes, it's not actually law.
It's not code, it's law. It's statutes. It's the laws of the state of Michigan.
Statutes and codes.
Statutes, no codes. The Uniform Commercial Code does not apply to this court.
Ouch.
All right. Do you want the child support review or not, sir?
I do want the child support review.
Okay. In that case, I will send this for a child support review. Ms. Cry, any questions, ma'am?
Nope.
All righty. I will look at your motion when I do receive it, ma'am. I don't know when it's scheduled for, but it was not scheduled for this morning. Okay.
That's what I thought this was for.
Yeah,
Okay.
no problem. This was for his motion.
Oh.
All right. Have a good morning to both of you. I'll send this to the front of the court for child support review. Have your most recent current pay stub available. Both of you.
I'm under the impression that there's a warrant.
Yeah, you do have a warrant.
I didn't notice a warrant, but that wouldn't come up on this file for this motion. That would be a separate issue. You might want to call the warrant department if you believe there's a warrant, because you can deal with that.
I wasn't properly served on.
Again, the court has no paperwork concerning any of your warrant. I don't have her paperwork for her motion. I can't advise on things that I don't have before me, because I need to look at them before to find out if they're properly served or not. Call the warrant office and find out what's going on. If you believe there's a warrant, this is the first I've heard of it.
This is the motion for support.
This is the motion for support, and that's why I'm sending it to the front of the court for child support review.
And this all is under the same thing. Why they issued the warrant? Supposedly.
No, that's separate issues. This is ongoing support. Your warrant is about back support, if there is one. Okay. Yep. Two separate departments. All righty. Good luck. Have a good morning. Take care, everybody. Motion's granted for support. Review. Okay. Admiralty Court. I love it. Let me get my. Okay, next.
We are here in the case of Caitlin Schutte versus Michael Buffum, case number 23-05665PH. This hearing is being recorded on Zoom and live streamed on YouTube.
And this matter has come before the court this afternoon on the motion of, well, it's actually before the court on a sentencing, for a sentencing hearing. A portion of the sentencing was imposed last time, that being the requirement to get fingerprints taken because of an entry of a finding of responsibility or guilt in violating the protective order by Mr. Buffum. However, the court left for a later day, likely because of time in the matter, the question of whether or not attorney fees are properly awarded. So, as an initial matter, counsel, why don't you place your appearances on the record?
Howard Vandenheuvel on behalf of.
I screwed up. Billy helped me edit. I got these out of order, guys. I am so sorry. I think this is number 2. And then we'll watch number 1 and then number 3. My bad. We're going to have to do this one Star Wars style. I'm so sorry.
Of Caitlin Schutte.
And on behalf of Mr. Buffum.
Thank you, gentlemen. And Mr. Vandenheuvel, it's your motion. Why don't you place your argument? I have, as I said, received and reviewed the briefs, although I've been tied up in an evidentiary hearing this week on a separate matter, and admittedly have not had an adequate amount of time to review those in their entirety.
Thank you, Your Honor. So basically, and I think the court touched briefly off the record, but I'm going to touch on, which we didn't touch in our brief on attorney fees. There is a statute that deals with attorney fees in PPO violation cases. The court, I know, is aware of that and has the power under that statute to award fees. under, for what has, particularly in this matter, when there's a violation of an established PPO that's been put in place, and this is a result of a show cause request. That has the power to impose both criminal and civil liability on a person. Now, we did cite in our case, I don't know why my power is blinking off and on here, MCL 600.1701 B, and I'm going to switch to that in a minute. I'm just going to go over to the statute 600.1701. And this statute talks about neglect or violation or duty or misconduct, power to punish by imprisonment. And it talks about in G, parties to actions, attorneys, counselors, all persons for disobeying any lawful order, decree, or process of the court. And in subsection F, parties to actions, attorneys, counselors, all other persons for disobeying or refusing to comply with any order of the court. And then that one talks about temporary permanent alimony or money or costs made in any action for divorce or other separate maintenance. So that one's not going to be relevant. I grabbed the wrong section there. Sorry about that. But it basically is section G for disobeying any lawful decree or order of the court and having the ability to follow it did not. So what we're saying is they had the defendant here or respondent did not had the ability to obey this court's order of a personal protection order and simply didn't. This would be a secondary argument other than the PPO statutes that apply. Now, we made some arguments that were more domestic related in our filing with a court. And I don't know, candidly, those arguments are, how do we put it? We put them in for more, for example, than for absolutely being directly on point. The point was that the conduct is knowing, it is harassing, and this is where I go switch from the legal part to the other part. So what we're saying is the respondent had the ability. PPOs do carry the potentially failed to follow the order. He's pled guilty to not following the order. So where do we go from here? First, we talk about should he pay attorney fees. Second, we talk about what should be done overall. I'm going to touch base on that.
I swear I thought he just said shitty paid attorney fees. My brain is broken, y'all.
My client has been the victim of him approaching, taking pictures, and on social media, flaming her in economic places where she's trying to sell or buy or trade things, saying she is a liar, she lies, and calling her other names, unpleasant names in the social media forums, and that's just horribly unacceptable. And there's been lots of name calling and none of it's been good. And it's resulted in her losing business, not being able to market items on the app, What's Not app, as well as other places where she's trying to do commerce and trying to, earn some money. But it's extended into public places too. And that's where the conduct has included attempting to run her off the road, taking pictures of her, and I take that more seriously probably than any, but also continuing to approach as if there's no PPO, and PPO specifically says you're not to approach or go anywhere. And the most recent incident happened just this past week again. The respondent was within 10 feet. We're going to file a show cause on that, actually, because he's within 10 feet and he's loudly talking about her with friends and family. It's just a complete disregard and contempt. It's contemptuous behavior in violation of the court order. And that's the really outrageous part. He keeps, he has his friends point and laugh when they're in the arena and carry on, go out in hallways, talk loudly, encouraging others to harass or approach. And like I said, the most recent was within 10 feet over in the arena. And as the court would advise any person that came before it with a PPO when it was issued, it would be, do not approach the person. If you see them in a public place, your duty is to exit, not to hang around, not to make loud comments, and not to make the person feel threatened, abused, harassed, or otherwise violated under the PPO statute. That's where this is outrageous, because he just keeps doing it without any regard for the law, and that's what's been going on. There was also a threat. Remember, in our initial petitions we put forward to the court, one of her friends, Cindy, I think it was Veld here. I'm French. I said Veld here, French. He sent her a social media message saying, "I'm going to wreck your life." That's a threat. There's no other way. That was sent on 10/16/23. We didn't do the hearing. We had the witness there ready to testify to this, but he pled guilty. But I take that seriously. These are both women. My client is slight. She's not a tall, big person. As you can see from the camera view, the respondent here is a bigger guy. And, you know, anytime male or female, bigger person says to smaller person, or indicates by conduct, I'm not afraid of you, and I'm going to continue unlawful conduct and be in contempt of court. I take that very seriously, and it's really outrageous, to be very honest with you. And that
he does not look like a bigger guy. They look roughly about the same size, him actually being a bit slimmer. I don't know where his attorney is getting off saying that, oh, he's a bigger guy, he's so much more threatening to her. He's really exaggerating there. But trying to run her over with a vehicle, I mean, that, I would take that seriously.
my client, both her and her mother are here today. They have victim impact statements they'd like to read to the court, but the conduct is here, and it just keeps going. And what she wants from this court is, she wants him to be ordered not to follow her on social media. And that is easy. You just unfollow somebody. He hasn't done that yet. Not to approach. The court gave a long conversation with him at the last hearing where we talked about not approaching her, and here we are again. And to not encourage or foment others to do the same, to look, to jeer, to point, to carry on. The arena isn't that big, and not to be able to appear at the arena or at the Whitecap stuff while she's there, period, because he doesn't seem to be able to control the impulse to stalk. You know, it should be pointed out, he had hoped to date my client or have some kind of relationship with her. Obviously, that's not going to happen. But this conduct just keeps going and going. Griffin's games, whatever. It was at the Griffin's game last time, this past week. So we've got to, I'm asking the court to put a stop to it. And if he needs, I think all options are on the table. Fortunately, you get to pull the trigger on that, Your Honor. But you know, I don't know what it's gonna take. I would like to see him pay the attorney fees. I think that would be a very instructive, but maybe jail's on the table for a short period to learn that when the judge warns you, you don't keep doing it. This isn't, you know, oh, a piece of paper that I kind of look at, guidance for what to do. It's the order of the court. So I've said my piece. I think I've very definitely, and there's been multiple witnesses. We've had to subpoena people. We had 4 witnesses. We interviewed witnesses. We've done a lot of work on this case to lead it up to what would have been a mini trial. And he finally said, yeah, I did do it. Well, okay. Here we are. Well, we need some help because it's still not going well. Thank you, Your Honor.
All right. Thank you, Mr. Van Heuvel. And just for everyone's information, and I'm not going to hold you to it because that, of course, is the purpose of the attorney fee evidentiary hearing, is to determine how much and how reasonable those fees are. If you had to ballpark your amount charged on enforcement of the matter, that is, what number are we talking about? Just round numbers.
I think And my system doesn't always tell me perfectly, so I'm gonna fudge a little bit. Our total, and I think we came in, we didn't file the petition, did we? I don't think we did.
No.
I think my client did, so I think we're mainly the enforcement end, and we're ballparking at about 9,966 excluding today. So we're climbing up because there's been a lot of work. Our file is, well, beauty of Zoom, as you can see, we've got
You got a chunk of paperwork there.
we've
No,
got a chunk of paperwork.
mine is correspondingly growing thicker than most PPO files do as well. So, okay. All right. I think I understand your turn. Let me give Mr. Hanel an opportunity.
Thank you, Your Honor.
As far as the attorney fees goes, I do think that most of the cases cited by the petitioner here are based on civil cases. I think you'd have more latitude for these penalties under civil contempt cases, but because this is criminal nature, I don't really think there's an avenue for it. I think the criminal contempt is more punitive than is remedial. And I think the 600.1701 is more aimed at dealing with misconduct in the courtroom, not necessarily a PPO situation. I think if attorneys are out of line or one of the parties is out of line, that would be one thing. But this is frankly not even a very unusual kind of PPO case. It's there's not violence here. There's I believe some of her allegations are somewhat exaggerated in this matter. I think they're both fans that go to the same location in many manners, but I don't think they have a healthy relationship. And I think I would agree with petitioner's attorney that this does need to be resolved. And I think any kind of social media contact or following that needs to be done.
I don't know how you rack up 10K in attorney's fees on a PPO case.
I think both of them want this over with. I know they were in a former dating relationship, I believe, and now they're both still the fans of the same sports team. So we've been stuck here. I think $9,000 seems like a ridiculous amount to have to pay for PPO violation. I think it's much more overly punitive than possibly contemplated by a PPO statute, considering we've had 2 hearings in the matter.
Well, I don't know. It could be 90 days in jail. That would equal about actually 90 days in jail is a bargain because it would only be about $9,000 by the county. So I don't know. That ought to be considered in the mix as well.
Okay, nothing further, Your Honor.
All right. Okay. Well, what I am going to do is I'll take this matter under advisement as to the awardability of attorney fees. I have awarded them in the past, not in the amount sought here. This is a larger amount, but as Mr. Van Heuvel points out, it's taken a larger amount of work because of some unique factors in the situation. And as I think I said in previous hearings, it's the first case I've encountered involving the sports card sale and resale industry and a particular app for that, and also to both petitioner and respondent who are very committed fans of our local professional sports teams and wanted to attend both games. And I will say for the record that my intention always, and occasionally I'll get PPOs against school kids who go to the same school or university or 2 people who work in the same workplace. I want to allow both people to maintain their regular work life or social life as much as possible, day-to-day activities, without, having to drop something, certainly not anything critical, certainly in the case of a job, I'm very hesitant to tell a person, well, sorry, you just can't work there anymore. Because of this PPO. Now, I also will say for the record, I have had a guy who in a thwarted romance type situation had a great job at UPS, which by my understanding is a freaking acres long facility. And for some reason, he just couldn't restrain himself from using the bathroom that was like 10 feet from where the respondent worked. And, she had a legitimate level of fear based on some initial, I can't even remember the conduct that got us there, but I do remember that I was astounded that this guy who was earning that good of money at that job was willing to risk it all. And ultimately he spent some jail time and he lost his job at UPS. Bottom line being, this isn't the kind of stuff that you fool around with or try to push the edges of. When I implement an order, I expect it to be followed down to the letter, and I will interpret it to the benefit of the person I'm protecting. That's, after all, that's the purpose of the PPO. It doesn't make it a two-way street or a power struggle where, gee, I'm trying to get away with as much as I can, or show, and oh, she does something to irritate me. Maybe I can jump back into this thing and poke the bear a little bit.
All right, so I'm just going to give a real super quick recap for everybody who joined late or isn't familiar. These two fine individuals are both huge Griffins hockey fans. Absolutely over the top, huge Griffins hockey fans. They did not date, but he wanted to have a relationship with her. He reached out to her. He got rejected. At some point, there was something about he tried to run her over with his vehicle. I don't know the details of that. Apparently, he got a temper. I don't know. I didn't see that part of the case. But they both do everything Griffins hockey. They're involved in the charity events. They attend those. They go to all of the games. They have season passes in different sections, mind you. And they both participate in the sports trading cards aspect of it. So that's where we're at so far. That's the amount of information that we all have.
No, the answer is you got everything to lose in the deal. Money, your liberty, if I put you in jail, included. So I'm going to say in no uncertain terms, I expect this to be followed down to the letter. Of course, if there is another violation, I will deal with it. But that means, boy, you're the one with everything to lose. I did not order last time that you not attend those games, but that's not off the table either. If I've caused people to lose their jobs and interrupt their educations, both of which I have on these, I won't hesitate a second to keep you away from a baseball game, a hockey game, or a basketball game. Don't think those are liberty rights that are protected to the nth degree. They are not. They're sports events. For gosh sakes, if you want to attend, sit in your seat. Don't film directed directly at the respondent or anything that could be even thought of as right at the respondent. You got everything to lose, and I don't know that you've gotten that message clearly enough yet, Mr. Buffum. I have a little hard time seeing whether or not this is, gee, I don't know what to do, or I don't want to do what I'm being told what to do. And if it's the latter, we're going to have a big problem, and I'm the one that has the signature authority to have the police come out and pick you up and put you in the Kent County Jail. So I'd recommend listening to what every word of what I say in that regard. There's a personality conflict. So what? Eventually you got to take a step back from it and say, what's this worth to me? So anyway, all that being said, I'll make my determination. I'll issue a written order on whether or not a award of attorney fees is justified. As I said before, I view this as criminal contempt. However, I've always viewed it as me having the ability to compensate a person for out-of-pocket losses, including attorney fees, necessitated by violation. So that's likely what I'm going to find, but I'll look at it under civil contempt. If either party wants to brief specifically the contempt route, because I heard from Mr. Vandenheuvel today that the briefing that I did receive and briefly review primarily would go towards, for example, a domestic case where The enforcement is a bit different than a contempt order. In general, a few people, although I'm not going to again say it's never happened, go to jail on a domestic case, whereas in the civil criminal docket that I handle, people go to jail or prison all the time. So, it's a little bit different arena, and I want to make sure I got the right fit here. And if I do order that the award of fees is proper, then I'll notice a hearing on the reasonableness of those fees, where Mr. Vandenheuvel would present the number of hours expended and his hourly rate. There is a study by the State Bar of Michigan to determine whether or not said rates are reasonable for a particular area that the Court of Appeals has directed me to look to for guidance. And of course, Mr. Handel can provide that too, to advise your client on, the reasonableness of what's being asked for. And then I'll come down to an order at the end of that. Also, it was mentioned that there are some victim impact statements. I think since those go to my determination, more so probably on the reasonableness of the amount, I'm going to hold off and I'll hear the victim impact statements at the next hearing rather than trying to remember them from now until then. You're also welcome to submit those in writing if that's the preference of your clients, Mr. Vandenheuvel.
I will talk to them about that, and if they're willing to submit in writing, otherwise we'll talk that over. I didn't mention my client has been seeing medical professionals over stress and anxiety over this, and I think that should go into the mix. And that's my
Well,
final.
and I will say that on this, the attorney fees, because they're directly related to enforcement of the order, I do view those as a straight path. I have had in the past people ask for those items. I do sometimes view those as appropriate for restitution where there's a criminal conviction, because of course that statute's much broader and allows me to encompass a lot more things, in terms of restitution. I am much less certain on its applicability here. You'd have to make a pretty good legal argument to convince me that it would be. I mean, not that it couldn't ever be, but after all, we got a whole civil practice out there for infliction of mental distress and things like that that could also result in that. So I'm much less certain about that than I am about your fees. But if either side wants to brief this any further, please get those briefings to me within the next 14 days, and I will issue my ruling thereafter.
Thank you, Your Honor.
Thank y'all.
Take care. Hope you get a good rest this week.
I'm looking forward to it.
Thank you, Your Honor.
We are here in the case of Caitlin Schutte versus Michael Buffum, case number 23-05665PH. This hearing is being recorded on Zoom and live streamed on YouTube.
And this case is before the court this afternoon for the order to show cause against Mr. Buffum regarding 2 additional violations of the court's personal protective order. So as an initial matter, I will advise Mr. Buffum of his rights. Mr. Buffum, would you please raise your right hand? Do you solemnly swear or affirm that your testimony today will be the truth and nothing but the truth? I couldn't hear you, Mr. Buffum.
True.
Very good. Thank you. All right. And Mr. Buffum, you understand that if I find you guilty of violations of the protective order, in fact, I think I already may have imposed some sort of suspended sentence in this matter, that the maximum I could give you on each violation is I could find you in contempt of court and put you in jail for up to 93 days and or a fine of up to $500. You understand that?
Yes, sir. Your Honor, if I can, we already entered a plea on this case, right?
I think the plea we entered was on the other case, unless I'm wrong, and we did it regarding all violations.
Your Honor,
if there's a new case, I have not been appointed to it is the issue.
I see.
You have not, Mr. Handel. These violations came after the last plea, so these are new.
Yeah, I see that, but it was filed as like an amended complaint, which is, I just don't really know what to do with that, because the way the appointment system works, it's usually you file that kind of stuff, and if you ask for an attorney, then they go through the MDIC, and then I'm appointed. But in this case, if it's an amended complaint, he's already entered a guilty plea. We can't really go back and just tack that on to.
Well, I don't think he's already entered a guilty plea as to the new, or has that already happened? I think the guilty plea.
No, on the older stuff, we entered a guilty plea, and then they just filed. It looks like an amended
Yeah,
complaint.
with some additional violations. Well, what I would suggest we do here today to accommodate that is enter a not guilty plea on behalf of Mr. Buffum. I will direct MIDC to keep you appointed on the new violations as well, Mr. Hanel. And
Okay.
then we can then proceed to a hearing on the new violations. And of course, I still have under advisement the question of whether or not I can award fees as part of a violation that Mr. Van Heuvel's firm has filed. So I'll continue to work on that. My plan there being to get an order, and then if I do order that fees are allowable, we'll have the requisite hearing to establish the reasonableness of the fees. And then secondarily, as we do that, we'll also set a hearing for this matter on these two additional alleged violations. I'll set an evidentiary hearing and enter a not guilty plea for purposes of today. That seem reasonable, counsel?
Yeah, that does, Your Honor. Thank you.
Yes, thank you, Your Honor. I want to clarify for Mr. Hanel, the amended was an amended motion to show cause on the form. We omitted one of the exhibits incorrectly, and so we refiled that motion to show cause with the correct exhibit. So it's two new alleged violations as the judge has described. That's what's going on here. And so just for clarification of your file.
Oh, okay. So we're putting not guilty on the two new allegations.
Yeah, on the two newest allegations. That's correct.
Okay. Just as a matter of housekeeping, we don't have to deal with this now, but we were told that she was kicked out of Van Andel Arena and is not allowed back there now. Is that true? Because that might affect the situation as far as sentencing coming up.
I am seeing a negative reaction for Mr. Van Heuvel and also Ms. Schutte, so I'm going to take that as a negative that that has not happened. So you know, the same terms that I have placed in place regarding the protective order are going to remain in place. And the Griffin season is still going, even though are they in the playoffs? What's going on with the Griffins right now? I'm sure everyone else knows better than I do.
I don't have a clue.
They're in the battle. They're in second place. Got 13 games remaining.
Okay, all right. So there is a bit of the season left to go. This issue still might come up in terms of both of you being at the same arena. Going to direct, of course, both of you to maintain the no contact. And for your benefit, Mr. Buffum, you know, if your dad's sitting beside you and he's filming her or something, that's not going to work either. You know, you just got to pretend for all parts and purposes. Like there's, like I say, that invisible force field that keeps you. You shouldn't pay any attention, direct any attention, anything, signals, anything like that towards her while the protector's order's in place. Because as I have said many times, you got everything to lose in the matter. So protective order will remain in place, and we will. Lisa, do we have a date and time for the next hearing?
Yes, we can do May 17 at 3:30 on Zoom.
Hold on, I'm going to check my calendar.
That works for me.
May 17 at what time?
30.
Yes, correct. I can do 2:30 on May 17.
3:30.
Oh, 3:30. Yes.
Okay.
You can work that late that day, Mr. Van Heuvel?
Why, yes, Your Honor.
Okay, very good. Glad to hear it. All right. Thanks all for your appearances today via Zoom. And with that, we are concluded.
I think I was wrong about being wrong. I think there's just so many hearings with these two, and I don't have them all. But yeah, the ones that I do have, they are in chronological order. But yeah, these two, they've been going through this for a hot minute, for a Michigan minute.
Thank you, Your Honor.
We are here in the case of Caitlin Schutte versus Michael Buffum, case number 23-056665PH. This hearing is being recorded on Zoom and live streamed on YouTube.
And today is the time and date set for, I believe we're in a continuation of the trial. Did I kick off testimony last time? Well, I'll let counsel inform me after they put their appearances on the record. So as an initial matter, counsel, will you place your appearances on the record? We can start with Mr. Vandenheuvel.
This is Attorney Justin Van Heuvel Law, if on behalf of the petitioner, Caitlin, in this matter, and it is my P number 79011.
Thank you, sir. And Mr. Hanel.
Thank you. Steve Hanel on behalf of Mr. Buffum. Your Honor, I think what happened last time, we have, I guess, two matters now. Last time, we were just waiting on a sentencing on the first matter. He entered a plea on the first PPO violation from last year, stuff from last year, I think. They filed another show cause, but I hadn't been appointed yet, so we set that out on that matter, and we haven't done anything on that yet.
Got it. So we have you appointed now, and we're here at least on a second show cause. Perhaps for me to make a determination at trial of the additional two violations.
Correct, Your Honor. So to put it in, the opposing counsel, what he's saying is there was a plea on the first violation, and we are going to sentencing, and then I filed two additional motions to show cause on additional violations stemming from February 22 of 2024, and then a follow-up on February. Hold on here, I'm pulling the exact date so I have it. And then again on February 24 of 2024.
Okay, very good. Well, my intention then today is I will conduct the order to show cause, and then we can immediately conduct, as long as the attorneys are okay with that, the factual trial on the additional violations, and then I can sentence on them all at once, which seems to make the most sense to me. Any objections?
No
That makes
objection.
sense. Yeah, that makes sense to me as well, Your Honor. I'm just making sure I have everything that they filed here. Did you see you filed two separate show causes?
There were two separate show causes. There was a show cause for the 22nd and the 24th of February.
Were they filed at the same time?
Yes, thereabouts.
Thereabouts, or I mean, I'm just wondering if I was appointed.
And I can look at the proof of service if you're asking, I guess is
I
what
wondered if I was appointed to both. Question.
you might have only been appointed to one. I don't know. I don't know your appointment, but there was a proof of service on March 1 for the second one. Sorry, I'm pulling my paperwork as we speak. And then there was a proof of service. Give me a second here for the 19th. And then there was a proof of service on on March 1st again for the second, and both were filed on the same day, March 1, concerning the 22nd and the 24th of February of this year.
Okay.
And just for your information, Mr. Hanel, I'll be happy to appoint you on the other violation purely for efficiency's sake here. You know, I think obviously since you've been on the case thus far, it makes imminent sense, you know, from an economic and practical standpoint to appoint you again. So that would be my intention. Of course, it also is important that you have a copy of the violation to look at. So.
Yeah, that's what I'm just making sure I have everything here. I thought there was one matter, but I might have that. You know, we've been here so many times. I know I've looked at this stuff a lot. Okay, I believe I'm ready to proceed though.
Okay, very good. Well, first let me advise Mr. Buffum of your rights. Since it is an order to show cause, Mr. Buffum, if you'd raise your right hand. Do you solemnly swear or affirm that your testimony today will be the truth and nothing but the truth?
Yes, Your Honor.
Very good. Mr. Buffum, you understand, if I find you guilty of violating my protective order, I can give you up to 93 days in jail per violation and or a fine of up to $500 per violation. You understand that? Do you understand that, Mr. Buffum?
Yes, sir.
And further, and obviously you're exercising your right to a trial today, you do have the right to an evidentiary hearing before I find you and right to be represented by counsel as you're here with Mr. Hanel today. So you understand that as well?
Yes.
Very well. And you wish to enter and continue with a plea of not guilty as to the two violations at this time?
Correct, Your Honor.
Very good. All right. Well, let's proceed with the fact finding on the matter. Mr. Vandenheuvel, I'll allow you to lead off.
Yeah, no problem here, Your Honor. I'm going to start with the violation that was first February, or the alleged violation of February 22, 2024. I can pull that up. I assume the court has a copy. Mr. Hanel, do you have a copy or must I show it on the screen?
I'm looking. I do have a copy. I do have a copy of each of them. Is this trying to figure out which one is which?
2/22/24.
Uh, 3/22/24. Wait, never mind.
The violation is to occur on 2/22/24.
Is this the one that involves the picture of him in front of the men's restroom?
No, that's a prior case. This is for the, it shows a picture of him standing in the middle of the, an auction. There's a color picture standing up. Yeah, the men's restroom sign is there.
Okay. Yep.
We're on the same page?
Yes, we're on the same page.
Yeah. That's, and we'll talk about where that is. Okay. Your Honor, I would call Caitlin Schutte, to the stand to testify in this matter.
Very well. Ms. Schutte, would you raise your right hand?
Yes, Your
Do you
Honor.
solemnly swear or affirm that your testimony today will be the truth and nothing but the truth?
I do, Your Honor.
Thank you. You may proceed, Mr. Vandenheuvel.
Caitlin, obviously you signed an affidavit in motion to show cause. Can you tell me what you recollect from February 22 of 2024?
This is the middle of the auction, correct?
Correct.
Yes, I can remember. I can recall that day clear as day, Your Honor. This is the ice house one. Okay. I was walking in with my mother, Kathy Chouette, who I'd like to also have as.
That's just testify to what you know.
Oh, what I know. Okay. And I had turned around and Mr. Buffum had proceeded to see me, did not leave, stood there for at least a good 20-25 minutes, Your Honor, speaking about me, making laughing assumptions about me with other members that were around. And I couldn't see much of it after the fact because I had turned my back because I was so scared and so disgusted with Mr. Buffum at that point that I was thinking, I've given you many warnings, Mr. Buffum, in other incidences where you continue to stand where I'm at and you don't leave. And I mean, Your Honor, I'm appalled that he would not leave and he's standing there making fun of me. And
Caitlin, would you say that was an attempt to engage you?
yes,
What kind of things were said?
I could overhear talking and muttering in the back, so I couldn't quite hear everything, but I know I heard my name several times.
Okay. Do you believe that the, how far was he from you approximately?
Maybe not even 10 feet,
Okay. So you could see him clearly.
very clearly.
Okay. Did you take a picture that day?
I did hear.
Okay. And did you attach that picture to your motion in order to show cause?
I did.
Okay. And I'm going to point the court to the attachment to the statutory motion in order to show cause. This is a picture that you attached.
That is Mr. Buffum.
Can you describe this picture for us?
This is exactly with him standing there talking with a bunch of members. I know that the equipment manager for the Grand Rapids Griffins, he's not in this picture, but I know that he was speaking about me to him to see if he could, telling everybody he had the PPO, when in fact, Your Honor, as everybody's overlooked, I'm the victim here. I am the one that should be, not scared where I'm located. And Mr. Buffum thinks that he has the PPO, but that's Mr. Buffum. I can guarantee you that.
Okay, so just describe what you're showing me here. You can't just point, you have to describe it because it's an audio record. So
That's Mr. Buffum's.
okay, somebody is kneeling
Mhm.
Okay, describe it more to me.
Mr. Buffum's standing there talking with others about me. I can,
What is he wearing?
he's wearing a black jacket, Grand Rapids Griffins jersey, black pants, black and red Griffins hat, and those are his glasses. And he's got brown hair and a beard.
Okay, and this is what's going on at this time.
At this point, he is still standing there talking about me and hasn't left, and that's probably, he stood in that position for at least 20 to 25 minutes after he had saw me too.
Okay, and you took the picture from where you were standing?
Yes,
Okay, and this was the approximate distance of?
yes,
Of,
Mr. Buffum,
okay, at what distance?
5 to 10 feet.
Okay. Your Honor, I'd move for entry of that exhibit. It's the picture of Mr. Buffum, within 10 feet of my client.
No objection.
Very well, the exhibit may be entered and I will mark it exhibit, petitioner's exhibit number 1 for this hearing.
Thank you, Your Honor. Caitlin, we talked about, you have a valid PPO, is that correct?
I do.
And it was signed what date?
6/14 of 23.
And was it extended?
It was
On what date?
12/5 of 23.
So is she more upset that he's at the location where she showed up? Or is she more upset that he's telling people that he has a PPO and they're not seeing her as the victim? Because it sure sounds like that's more of her gripe. He was telling people that he has a PPO and I'm the victim. I'm the victim. Sounds like you are enjoying being the victim.
Okay, and in that order, does it give specific terms about the conduct of respondent in terms of how close he may be to you?
I believe
Okay.
so.
And he was obviously, and I'm looking, you feel uncomfortable and unsafe.
I do.
What brings you to that feeling?
Him and all of the priors that he's done, he's made me feel really uneasy. I'm gonna go back to the date of June 7th, when it all started, when he chased me down the highway, and was behind me and almost ran me into the retaining wall.
So you have what would say an objection, you have a fear because of this?
Yes,
conduct.
very big fear. And it's just, he's been violent towards me and everything. I would feel like, he's spoken about me. He's made threats, especially to my friend Cindy French, that I want to bring up.
Okay, but what, has there been any other contact between you since this date of 5, what date?
Believe so.
Yeah, so
Yep,
what,
the
the
what
date,
not.
we're on an audio recording, so you have to speak.
Oh.
And not just say, or point. So since this date that this incident occurred, can you say that date?
February 22nd, 2024.
Okay, and you've had other contacts since then?
Yes.
Okay, where?
Whatnot, he was again on Whatnot as of even Wednesday, this past Wednesday, as of 5/15/24.
Okay, and hanging out, I mean, what does whatnot mean? Explain this to me.
So Whatnot's where I have also had my,
Object to relevance, Your Honor. I don't think this whatnot stuff has anything to do with these violations that have been filed.
Your Honor.
My recollection is that we've had prior testimony about, kind of postings on what I believe was Whatnot, if it's the baseball card sales site or sports card sales site. I'll overrule the objection. It could potentially be relevant. If you'd please connect that up for me, Mr. Van Heuvel.
I will. Your Honor, we are moving for this and the testimony will show here that there is a continued pattern. This court has already talked about not having contact in digital forums or otherwise. We now have in personal forum and digital forum continuing. And so my point of bringing this conduct up is that it is a continuing pattern of conduct.
All right, go ahead. You may proceed.
So on 5/15/24, you had you just testified that was the time you last, and I should be clear for the record, 2024. You had contact, he had contact with you through that.
I saw him in the room. He had saw me join that room and he did not leave. He proceeded to sit in the whatnot room where I have a business of selling cards and continue to do that.
So you were selling cards and he was,
I wasn't selling my cards, but I was in the room.
Mind you, she's not speaking of a physical room at this moment. He was in a chat room, like Facebook Marketplace or Messenger, basically, where dealers sell cards and patrons purchase cards. So he's in a chat room talking to someone about purchasing their cards, and she's upset because she can't be in that virtual chat room if he's in there.
About to purchase cards for my business, and
Okay.
he had saw me in there.
and continued to post in that chat. We'll
Yeah.
say in that form.
Yes.
Okay. Tell me about, has there been any other, I'm gonna move forward to, you had other violations, is that correct?
That is correct.
Okay, and I'm gonna move forward to a new date. We filed one, I remember here, you signed an affidavit of motion. What date did you have more contact with Mr. Butler?
February of 2024.
Okay, and on that date, what happened?
I was sitting there and in a Jersey auction waiting for Mr. Velder, who was
Okay.
not in the room.
No, that was never made part of their order. Not officially. Because they both have season passes to those Griffin games, and they both have different assigned designated seating areas. The judge did not make it a part of the PPO that he has to leave. It was strongly recommended. He's not allowed to have sustained contact. If he sees her, it's better judgment for him to leave because he cannot be threatening or intimidating. But in regards to all of this Griffin sports stuff, nope. He can participate just as much as she can participate. He just can't interact with her.
Waiting for him at the top of the stairs where Mr. Buffum proceeded to sit all but maybe 10 feet from me again, sitting down there at the bottom, talking with his friends, and looked back several times trying to intimidate me to the point that his own father had stood up to take pictures of me and had even yelled out that his son has a PPO, not me, and is actually it's the other way around, to get me kicked out of the Vandal Arena and to get me removed.
So you were actually approached then by staff saying that you.
I was
Okay,
correct, and I had to stand
you
up.
didn't direct that staff.
No, I did not.
You know, you saw. So you were, so explain how far away you were from this gentleman.
Probably 10 feet.
Okay, and so sitting in seats, or I mean in a.
I was sitting in a seat from, are you asking about his father or are you asking about him?
Father.
His father, 5 feet.
Okay, and you then saw or heard the request?
Yes, it was very loud. It was in fact loud enough to all the people in the arena had actually heard it in that auction.
So you had personal knowledge of this attempt to have contact?
Yes.
Okay, and then what happened?
Then he had went down the stairs, the security had went down the stairs, the guy that was running from the Griffins, to speak to Bachelor to try to see what was going on, who had the PPO and what had happened.
So we're not trying to testify for him, that's your belief of what happened. He went to go try to figure out.
Yes.
So you're not saying that that's the truth of the matter, you just believe that he went to go try to figure out what happened?
It made me believe that because he had then came back up the stairs, the Griffin staff member had came back up the stairs to ask me more questions about what was going on.
Okay, and that's how you knew for sure that there had been an attempt to contact you?
Yes.
Okay. Did they at any time look and point at you?
Yes, several times.
Okay, and you attached an image to this amended motion to show cause for violation of personal protection order for the date of 2/24/24. Okay, and let's look at those images. The first one has a label on it. Can you read that for me?
That's Paul Buffum, respondent's father.
And you believe he's holding what?
A camera. I know that he was taking pictures of me because he kept making the motion of taking pictures.
Okay, and then there's some more in this series, right?
Yes.
Okay, so what's this? The next one.
That's Mr. Buffum standing no further than 5 to 10 feet from me.
Okay, and
And he did this every Jersey action, as a matter of fact.
okay, so he regularly in your presence
Yes.
within 10 feet.
And it made himself well known as well. Him and his friends made themselves well known.
How?
They would stand, they would point at me, they would laugh at me, they would make me feel intimidated. They would try to make me leave any area in which they were in because they thought that they were large in charge.
So like that first picture here?
Yes,
Okay.
he's doing that to try and make me feel intimidated so I would leave.
That first picture is he.
That's Paul Buffum.
Oh,
That's
we
the
have-
defendant's, or that's
Yeah.
his father,
And you labeled that. And the second picture is,
Michael Buffum.
okay, and then we're gonna go to the next one in the series.
That's Michael Buffum again.
We're talking about the third picture, right?
Yes,
Okay, and he's wearing,
black hat, black coat,
Okay.
black pants like he always does.
okay. And then you've got a fourth picture again,
Yep, that's Mr. Buffum as well.
okay, and what is he doing?
Sitting there talking to people, trying to get them to make me leave
Oh, okay,
and make me feel intimidated. Because he pointed and laughed at me several times.
all right. Your Honor, I move for entry of these images.
Any
Yes.
objection to the images, Mr. Hanel?
No objection, Your Honor.
They may be admitted and correspondingly numbered. I think we're to maybe 2 through 7.
Yeah, we are, it should be exhibit 2 because there's all one set of pictures, Your Honor, but if you
Okay,
want to do 7, that's fine too.
yeah, that's fine. Let's just keep those together and make them a group exhibit number 2.
Appreciate it. And so this isn't the only contact he's had with you, right? He's directed his mother at
That's
some
correct.
point. And what do you know about that?
I know that his mother went as far as contacting Matt Batchelor, regarding to find out if I was kicked out from the Griffins and if I was in fact removed from the Van Andel Arena on
And,
his behalf.
and how do you know this?
Matt Batchelor had sent an email to my mother and then I saw that.
Objection to hearsay.
And obviously I have.
Uh,
in those-
Let me get the response on the objection to hearsay.
I'm putting foundational evidence in for the admission of this email. I need to quickly scan this and put it up on our screen here to review, but there is an exhibit that my client brought in today, a copy of that email between Laura Buffum and Matt Batchelor. So I'm laying the foundation for it to be entered. It's written communication directed by, we believe, obviously the testimony suggests it's directed on behalf of Mr. Buffum. It's in a statement then against party opponent.
Well, it'd be a statement of the party opponent
Correct.
by, you're saying, relayed by Mr. Batchelor?
Correct.
Okay, why don't you go ahead and lay the rest of the foundation?
So you're reading this email. Do you mind reading, go ahead and read this email for me. What does it say?
Absolutely. This was not anyone from the Griffins. That is why I asked you if it was true. I think it was a bunch of rumors. Sorry about bothering you about all this drama sent from my iPhone.
Okay. And the person it was to was,
Matt Batchelor,
and the person it was from?
Laura Buffum.
Okay. And so this email makes you believe that that the respondent in this matter was trying to have direct contact regarding you.
Yes.
And regarding you being kicked out.
Yes.
And you believe that, can you establish that foundation for me? Why, let's connect these dots. At the last hearing,
Mhm.
Was it, what do you recall of that last hearing regarding this issue? We all were together.
Yep. I didn't even know that I had been removed from the from the Griffins at that point. And then all of a sudden this shot through the tubes. without me even knowing.
And you weren't actually removed.
No, I was not.
No, so this is in response to, obviously, and do you know who Laura Buffum is?
I do.
And how do you know that?
I know Laura Buffum's his mother because I had met her once.
Okay, so it's your belief that this is directed
Yes,
on behalf of,
on behalf of Mr. Buffum.
okay.
Can we see a copy of that email?
Yeah, I'm gonna run it through the scanner. Just give me a second here. I'll pop that up if we could take a short break. I just got it today, which is why I don't have it scanned yet. Let me get it.
All right, go ahead and scan it, and then if you'd email it to Mr. Hanel, I'll take Mr. Hanel's objections, if any. And if I allow it, then you can display it on the screen. If not, we'll proceed from there.
Sounds good. Give me just a quick moment. It won't take me very long. I have my secretary mail them. Do you have them, Judge?
Let me take a look here.
Would be to Lisa and Wendy, just in case.
I haven't gotten it yet.
Yeah, I don't see it in my inbox either. But why don't you go ahead and lay the foundation for it, and I can rule on admission. And then did get a whiteboard, it looks like, for Mr. Hanel, but that's different.
Yeah.
Okay.
And then, all right, we'll get him back.
That was a mistake, Your Honor. I'm sorry. I was just trying to figure out how I could share a screen when I had shared my picture in a minute. I hadn't done that on Zoom before, so.
All right.
Okay,
Not a
it's back
worry,
on the record.
Mr. Hanel, I'll gladly delete you.
Are we ready to go back on the record?
Yep, we are back on the record. I don't know where Mr. Hanel went.
I'm here.
We are on the record, Judge.
Very good. All right, back on the record, in the matter of Chouette versus Buffum. Go ahead and lay that foundation that you were started on, Mr. Van Hubel.
Yes. So we just, Caitlin talked about that email, and we talked about your belief of where it came from. How did you come in possession of that email?
Matt Batchelor had given it to my mother, who was a season ticket member, and my mother had brought it to my attention.
Okay, so we'll call your mother for foundation of actual possession and chain of title. I want to shift.
I'm not worried about possession or chain of title. I won't object to that.
Okay. At this point, I can't move until you guys have a copy, so I'll move forward on my additional testimony.
He's not objecting because he wants that email in evidence.
I have an image of the original PPO here. I have a PDF, and the court has this in their file from the initial order. It was an order, and we talked about the dates of these orders. Is that correct?
Yes, we did.
Okay, and it says it is ordered that on page 1, line 5.
Yes.
What are some of the things that it is ordered not to do?
Following or appearing within sight of the petitioner, appearing at my work or residence, approaching or confronting the petitioner in a public place or a private property, sending mail or other communications to the petitioner, contacting the petitioner by telephone.
Okay. And has any of this happened to you?
Yes.
And you believe why?
Because I fully believe that Mr. Buffum thinks this is just a joke and that nobody will ever do anything to him for that. And that he continue to victimize me over and over and over again.
Objection. That's just subjective belief. She's here to testify of facts and things that happened.
Okay, I can lay a foundation for that belief. Miss Buffin, what brings you to the belief that you completely Miss Schutte, what makes you believe that this is true? That you are going to be, so they've objected to your subjective belief. They're saying that you feel threatened.
Yes.
Why do you believe that is true?
I feel like this is true because of all the violation after violation, the continuous contact, the continuous to have his friends reach out and do things such as, he had one friend I can remember back to this day, growing up his Griffins game. He had one of his friends sit above my head to listen to everything that I was saying with a set of my friends. Griffins games, he would sit, he would point, he would laugh. he would, to the point I had to change my lifestyle completely around so that way I wasn't where he was at. And I shouldn't have to change my lifestyle for him. I'm the victim. He is not.
So he would turn around, you're saying?
He would turn around all the time and come near me. Every
Okay.
chance he would get and every opportunity in which he had, he would find a reason to violate. He
I'm
would,
going to object because this doesn't seem we're getting outside of the scope of what these two violations are. We're on notice for specific things here, and now we're getting off in a Never Never Land where we're not having specific instances. It's vague, things that possibly could have already been dealt with, or maybe haven't been filed yet. But I think we should stick to what we're here for.
I believe she's speaking of some of the other things that have happened, but specifically the pointing and looking, and we have pictures and images attached to the violation. That's, I believe, what she's describing.
Let's keep them. I think we should keep them to the violation and what we're talking about, not just
all right.
Whatever's coming.
Okay, well, and I will rule on it. I've noted the objection there is to relevance and, to some degree, a narrative response that's non-specific as to the particular incidents. I have heard specific testimony about these incidents and about pointing or perhaps overhearing your name used by the other person. And I would agree that testimony should be limited to the two specific incidents. And I have heard the testimony about pointing and looking in that direction and, perhaps at least speaking about the other person loudly enough to be overheard. So with that, that objection will be sustained. You may proceed, Mr. Van Heuvel.
Thank you. I would like to, we should have the images now of the two items that we've previously taken testimony on, the email and the sports website.
Okay, I have received those. Go ahead and continue with your foundation.
Okay. We've talked about this email between Matt Batchelor and Laura Buffum. At this time, do you believe this email with Laura Buffum, this is related to that time on, and I'm going to go back to 2/24/24. Is that correct? Okay, and it relates to the images that we proposed as Exhibit 2, correct?
Yes.
The pointing.
Yes.
Okay, and what brings you to that belief?
The factor that they kept telling everyone that they wanted me out of there, him included.
So there
Him
was
being
family
Michael.
present that day.
Yes.
Okay, I move for entry of that email between Laura Buffum and Matt Batchelor.
Objection, Mr. Hanel.
You sent me the email, is that right?
Yes.
Just a second here. I mean, I'm looking at this email. I don't see how anything indicates it was directed by him. I can very much see how a family member would. I mean, they're concerned about him getting in more trouble. I can see why they would be asking about this kind of thing, but it doesn't look like it. I just object, I guess.
All right. Well, there's been an objection to the email. As to its relevance, I would take it. It is quite non-specific as to what it's referring to within the email. However, I do believe that there are tidbits of relevance in there, in that there has been testimony today about the engagement of Mr. Buffum's family members, and that, they may be acting as extensions or trying to communicate with Ms. Chouette as proxies or substitutes for Mr. Buffum, knowing that he can't do it. And, frankly, it kind of makes sense in a feud like this one that family members often do take sides. And so I will admit the email at this time as an exhibit for the limited purpose of establishing the context of the ongoing conflict between the parties, and the fact that it has, at least at this case, appears to have engaged Mr. Buffum's mother in the conversation, along with Mr. Batchelor, who it seems undisputed is a manager at the Van Andel Arena where the Griffins play hockey. So all that being said, it may be admitted for that limited purpose. You may proceed, Mr. Van Heuvel.
Thank you, Your Honor. Caitlin, we've obviously looked at this exhibit together. We've talked about it, about sports card. Remind me of the website.
Whatnot.
Okay. And what date did this happen?
5/15. So this past Wednesday.
And you're moving to, we're looking at this because of.
I have a card business myself and was going to purchase from this seller.
Is this a continuing pattern of contact?
It is.
Okay, and it started on 2/24?
It has.
Uh-huh, and have you seen any stopping to this contact?
I have not.
How is he supposed to know that you had made a choice to purchase from this particular seller on this website?
Okay, I move for entry of this exhibit of the whatnot form for shopping.
Mr. Hanley, your response.
Just a moment, Your Honor. I guess I don't object, Your Honor.
Okay, then it may be admitted. I think we are to exhibit 4 now, since we treated the one group of photos as 2. Let's mark this as exhibit 4. You may proceed, Mr. Van Heuvel.
Agreed, Your Honor. I am done with direct examination of my client, obviously, indirect, sorry, and I would, and I have another witness to call.
Very good. Let me give Mr. Hanel an opportunity for cross-examination.
Thank you.
Okay, let's start back at the beginning. I think we were here first on. We're looking at what I believe is Exhibit 1. You see a picture where it's got the men's restroom in the background. His back is to you. Is that correct?
That is correct.
And your testimony that he stood there for about 20 minutes like that in that
20 to
position.
20 to 25 minutes, Mr.
Where
Hanel.
was this at?
It was at the Griff's Ice House, Mr. Hanel.
Okay, so he was standing there and you got within 10 feet of him. He didn't come to you, right?
That is incorrect, Mr. Hanel.
Well, you said he stood in that position for 20 minutes. Why were you within 10 feet of him? Did he come and stand next to you, see you, and turn like that?
Can you repeat your question?
So you're to his back. He's not facing you, correct?
He was facing to me at one point. He had saw me come in that door and he proceeded to stand there and stare at me.
Okay, so he was there first, correct?
Not in that position, Mr. Hanel. Every time he gets an opportunity to come within 5 feet of me, Mr. Hanel.
Was he there? Can you answer the
Mr.
question?
Hanel, can I
Was he there
proceed to answer
first?
your question, sir?
Was he there first?
Hang on just a sec. This is cross-examination. You will have, Mr. Van Heuvel will have an opportunity to redirect to allow you to clarify your answers. But if Mr. Hanel's question does call just for a yes or no answer, you should respond with a yes or no, and then Mr. Van Heuvel will have the opportunity to redirect and clarify those questions. It's just the way that cross-examination needs to work. With that, you may proceed, Mr. Hanel.
Thank you. So he was there first, correct?
No.
So you just testified a second ago that you walked in the door and he
Yes,
saw
I'm sorry. Yes, I didn't understand your question.
Okay, so he was there first, correct?
Yes.
So he may not have been in the position, but was that where he was standing?
Can you repeat?
Was that where he was standing in the room? Does this picture depict where he was the whole time?
Yes.
Okay, so your testimony is you came in the door, correct? And he was standing in that spot.
As far as I believe.
Okay, and you got within 10 feet of him, correct?
Yes.
Okay, and you fear for your safety.
Yes.
Okay, and you get your phone out and you take a picture of him. Is that correct?
Yes.
And you stood within 10 feet of him while he has his back to you for approximately 20 minutes. Is that correct?
He's moved all around at this time.
Is that correct?
No.
Okay, so he's moved around the room.
Yes.
Okay, did he move closer to you?
Yes.
Did he say anything to you?
No.
Was he looking at you?
Yes.
So if you took a picture of this, why didn't you take a picture of any of the other conduct that happened? If you said he moved around the room and was looking at you, why didn't you take a picture of that?
I'm gonna object. It's a negative question. It's a question without that calls for speculation.
Well, so you took a picture of him when he was 5 feet away from you, correct? And you were feeling threatened. You wanted to document that, presumably. Is that correct?
Yes,
Okay, so and now you're saying, now your testimony is stating he moved around and got closer to you. You didn't take any other pictures of that. Is that correct?
no,
Okay, so you heard your name mentioned between him or his friends. Do you know if it was him talking or his friends, or you just heard it in
Him.
general?
him specifically.
Okay, did you hear any of the content other than your name?
No,
No, I'm going to direct you to the next group of pictures, which I maybe exhibit 2 now, which would be, you see the ice rink there.
Pulling it. Exhibit 2.
I believe it's exhibit 2 now. I don't know if we went 2, 3, 4, if it's one set. Now, we'd been here in court before, correct? And I believe possibly even before I was involved there. At first, it was agreed upon that you had a section and Mr. Buffum had a section. Was that correct?
no. That was not.
Your seats are not in this section where this picture is taken. Is that correct?
That's correct, but that's where the auction was, sir.
Well, was it just that section where the auction was?
Yes, sir.
And was he there first, or were you there first this time?
That should have nothing to do with this.
Just please answer the question.
Answer the question.
Yes, he was there, but I'm a season ticket holder too. I should be able to go to an auction if I want to.
Was
And I
he
shouldn't have to change my life, Mr. Hanel, for him.
was he in his season ticket seats?
No,
He was not. Where are his ticket seats from there?
at least 20 feet.
Are they in that section?
No,
What section are they in?
where his father's standing in that photo.
So now I see now in the briefs provided by your counsel, and I think this was discussed later, that his section is 121 and yours is 114. Is that correct?
That's correct.
Okay, and we had discussed at a prior hearing that this might be able to work because you were in different sections and there's some kind of, it wasn't easy to go back and forth between the two of them. Is that correct?
I'm sorry, can you repeat?
We had
Can you ask it in a different way?
okay, we had discussed we were talking about whether Mr. Buffum should continue to be able to go to the Van Allen Arena. We decided because your sections are separated, that as long as there shouldn't be an issue if you were in separate sections, correct?
Correct.
Okay, I want to show you. I'm going to try to do this. I'm going to show you a picture. I haven't done this on here, so be patient with me. You see this picture?
Yes, we do.
Okay, now who is that with the camera in your hand? In her hand, is that you?
That would be me.
Now, would this be the time and date that you were taking the picture of Mr. Buffum's father?
That was after the fact that Mr. Buffum's father started taking pictures of me and started this whole incident.
Okay, yes, this is the same time, right? Does this picture accurately reflect that moment from the other perspective of the camera?
Yes.
Okay, I move for admission of this as I think are we at 5 now or 6?
Yeah, or actually, why don't we do it just as Respondents Exhibit A?
Okay, thank you. And in this picture, can you tell me what numbers there are right there behind you?
121.
Okay. And as we've indicated, that is Mr. Buffum's season ticket section. Is that correct?
That's correct.
Now, are you no longer welcome at the Griffins games? Is that correct?
That's correct.
Okay, so and how long what'd they tell you? How long are you banned for? Do you know?
I'm not going to answer that.
You need to answer. I'm sorry. Mr. Hannell, can you re-ask the question?
How long are you banned from the Griffins games or from Van Andel Arena? Is it both? Is it Van Andel or
It's
just
not,
the game?
it's not both, Mr. Hanel. That's where you're incorrect, and that's where your client's incorrect. I'm no longer going to the Grand Rapids Griffins games for the rest of this year.
One second here. Was there an incident where you stole or you took a T-shirt or something similar from a child?
No,
So if there were testimony here from someone that indicated that that's why you were kicked out of the Van Andel Arena, it would not be corroborated. Is that correct?
I'm gonna object on relevance. Where does this go to whether there's contact between petitioner and respondent?
I think your email is trying to. I'm trying to feel. It seems to me the purpose of the email you provided was to indicate that he had something to do with her being kicked out of the Van Andel Arena.
I think.
You're responding to mom's email. Okay.
Our response would be we proffered the email for the purpose of contact, not for the purpose of showing that there was a T-shirt stolen or she was in or out of the arena.
Okay. And you.
Yeah, but she tried to make it seem like she was getting kicked out because he and his friends were making comments. Remember, she was saying they were saying it so loud that the arena manager came over. They were saying that they don't want me there. Well, okay. But that had absolutely zero effect on you getting kicked out, because the reason you got kicked out was you stole a T-shirt from a child. Oh, man.
You're saying that's what well, I mean, really, I guess the main thing is that the email concerns Ms. Chouette rather than if she was kicked out, why she was kicked out, etc. I'm struggling to see the relevance of the basis for her being kicked out, unless it was somehow related to the interaction with the Buffums. So I'll sustain the objection as to the reason for being kicked out. She has testified that she was. Ticket holders were suspended for the duration of this year.
Thank you. Okay, now I think I might have missed a little bit. What exactly did you testify was going on with this WhatsApp picture? This happened last Wednesday, is that correct?
that's correct.
Okay, did he talk to you on that app or?
Mr. Handel, do not, I'm trying to be polite here, but at the same time, Mr. Buffum's not supposed to be, and it was directed by Judge Rossi here that he's not supposed to be located on any, you guys have come to the conclusion that he's not supposed to be on Whatnot at all.
I'm not
Therefore,
worried about you being polite. I'm just asking you, did he speak with you on the app? That's the only question. I'm not trying to I'm trying to be rude to you. I know it's hard to do this, but I just want an answer. Did he speak with you on the app, or was there any contact between you and him on the app?
there was contact about me, not as of Wednesday, but a prior date, and the judge has pictures of that.
So I mean, we're talking about this picture right here that was just provided today as an
He
example.
was located in the same room as I was, and so I felt intimidated to not be able to even purchase cards for my own business because he was in there.
Was he talking in there, or how do you know
He
it
was
was him?
speaking in there. If you take a look at the picture clearly states Buffum. How much for a box of Trilogy? Buffum. Thanks. Buffum. Again. Go Wings. This is Wednesday. This is 2 days before this hearing. And the seller was 314 Sports Cards.
No further questions, Your Honor.
Okay, all right, thank you. Any redirect, Mr. Van Heuvel?
Yes. Caitlin, I'm gonna talk to you again.
Mhm.
So you need to be in the camera view for recording purposes. No problem. Can you hear me well?
I can.
Good. They brought up, I will say respondent brought up, this, email again,
Mhm.
one from Laura Buffum. And the reason you're putting this forward is what?
Because it was contact on his behalf to ask again about what I was doing, where I was located, what things about me. And in the PPO, it says that he's not supposed to have contact with even through third party about where I'm located, where I'm at, and what I'm doing.
I'm gonna talk about that day on the 24th, February 24th.
Okay.
And we've all looked at exhibit number 1, or
Mhm.
number 2, sorry. The trilogy of pictures that have both Michael and, I'm sorry, Paul and Michael Buffum, is that correct?
That's correct.
Okay. And on that date, there's an auction going on you testified to?
Yes.
Okay. And explain what happens. You know, start from, I moved from wherever to this auction.
Okay. So I started in 114. I had asked Rita Miller, which is the lady that sits behind me. I asked her if she was going to the auction. She said, of course she was. So I had moved from 114 over to 121 where the auction is located. I decided to sit up towards the top because that's normally where Rita sits. And I was also waiting on Travis Valdir for him to use the bathroom. He was out going to the bathroom, came back. By this time, Paul Buffum, can't say Mr. because we have two. Mr. Buffum has now turned around, taken plenty of pictures of me, went down, told Griffin staff that in fact his son is the one that has the PPO, which is false information.
And you're under that belief, how?
Because I heard him very loud and clearly.
Okay. So the next picture in the series is,
Michael going to sit down in the front row to go for the jersey auction.
all right. During this time, you didn't flag them down anyway.
No,
And you didn't have your phone out first.
no,
They showed a picture of their exhibit A, defendant's exhibit A. And you remember that picture?
I
right?
do clearly.
You with your phone out.
Yes, that's after the fact that his father was taking plenty of pictures of me.
So in other words, you didn't flag any contact.
No,
Okay. And what made you aware of that contact from them?
when I had gone and so I was sitting there, a Griffin staff member, after they had gone down the stairs to go speak to Mr. Batchelor, decided he then would come up, the Griffin staff member would come up and they would apologize to me and say that they understood what was going on from the whole situation. And in fact, they understood I had the PPO, not the other way around, that Mr.
Hearsay.
She's just testifying to her understanding of how the contact occurred, Your Honor. We're not putting it for the truth of the matter asserted that Griffins believe one or the other parties has a PPO.
Okay, and I think I've got a grasp on that context at this point, so I'll overrule the objection. You may proceed.
Thank you, Your Honor. Caitlin, I want to go back to the 22nd.
Mhm.
And you've obviously, and I'm going to pull up, petitioner's exhibit 1. And, we're going to look at that again, Mr. Buffum, I believe, standing here. Is that correct?
That's correct.
Okay. And under a men's restroom sign?
That's
All
correct.
right. So I've identified the exhibit clearly enough for you.
Yes.
We've talked about who came or went. What was going on in that event?
I was there for, it's a sludwing game
Okay.
for the Grand Rapids Griffins, who I was friends at the time with a few of the players.
Oh, so is it a charity event?
It was a charity event.
Okay. And you were there to bid or provide money to the charity?
I was there with my mother to watch the players play and do the sludwing event.
Okay. And did you stay pretty static in that room?
I did,
Okay. And
to
what
the
was-
point I was not And the only reason why I knew Mr. Buffum was there is I was currently speaking on the side with one of the players.
So away off to the side of the room.
Yeah, not too far from
You
him.
didn't walk up to Mr. Buffum.
No, I did not.
Blue table, it looks like.
No, I did not.
Okay, did he move around?
He moved even closer.
So were there other places to be?
There was plenty of other places to be. There was another room that Mr. Buffum could have gone in. He kind of gone right into where the ice area was, where they were going to play that sled game. This room was large.
So there are other places in that room to be.
Yes.
You could stay more than 10 feet apart.
Yes.
Okay. And obviously you were to the side of the room.
Yes.
Okay. Your Honor, I have nothing further from this witness.
Okay, I do have a couple questions, Ms. Schwett. First, as you did mention that you heard Mr. Buffum talking about you. When he talks about you, does he refer to you by Caitlin or Ms. Schwett? How do you know it's you?
Caitlin, he says my name.
Okay, all right. And you're not aware of any other Caitlin that you mutually know that he might be talking about?
No, Your Honor.
Okay. And then second, the 314 sports sales area on the Whatnot app, is that your business or is that another person's?
That's another seller that I was referred to by Bun, which is another seller on the app, and told me that he would possibly have some cards that would be beneficial for my business.
Okay. And do you trade in the trilogy cards too, or just sport cards?
I trade in everything, Your Honor.
Okay, so just general cards in general. And when and I've never been on Whatnot, when another person enters the room, can they see everyone else who's in the room at the same time?
Yes, Your Honor.
Okay, so he would know by what's your handle on Whatnot?
It's Shuette_Caitlin.
Okay, so
it's very clear that it's me, Your Honor, and
got it. It's not like you're Tinkerbell or something like that. So
no, Your Honor.
Got it. Got it. Okay, those are all of my questions. Any further cross-examination, Mr. Hanel? And any further redirect, Mr. Van den Heuvel?
Nothing further, Your Honor. I have a second witness.
Very good. Then Ms. Chouette may step down from the witness stand. You may call your next witness.
Chouette, if you stand over here.
Good afternoon, Your Honor.
Call Kathy Chouette to the witness stand.
Very well. Thank you, Mr. Van Heuvel. And I do need to disclose, I know Ms. Chouette, as we used to be co-workers at the United States Attorney's Office.
Mortimer Duke, you get your wish. The witness is her mother.
Ms. Chouette at the time, I believe, was working in the victim witness office there at the time. I was an assistant U.S. attorney in the civil division. However, I think we might have been on the same floor of the 300 Ionia building from about 2002 to 2010. I wasn't aware that the same Mrs. Chouette involved in this case, and did have friendly conversations as co-workers, but it was quite a while ago. I believe that I can proceed without prejudice. However, I do feel anytime I know a person outside the context of a case, it's important for me to disclose that pursuant to the canons of judicial ethics. So, in the event that you think that that would be an unduly prejudicial, certainly I would invite, Mr. Hanel on behalf of Mr. Buffum to move to recuse me from the case and another judge be appointed. However, as we sit here today, I believe that I can both evaluate Ms. Chouette's testimony as a witness and further rule on this case without any bias or even the appearance of bias. So, however, I do feel that it's important to disclose the information. So, all that being said, do you wish to make that motion at this time, Mr. Hanel?
No, Your Honor, I'm okay with you remaining on the case.
Very good. And if after consultation with your client following, you feel a motion to recuse me is appropriate, of course, you can file that anytime. Ms. Chouette, I'll have you raise your right hand. Do you solemnly swear or affirm that your testimony today will be the truth and nothing but the truth?
I do, Your Honor.
Very good. Thank you. Mr. Van Heuvel, you may proceed.
Thank you, Your Honor. Kathy, do you mind if I refer to you as that?
That's great.
Okay, because there's two obviously Schuetz in the room.
Yes.
We, and I think we need to lay some ground for how you would, you know, you work in the legal field.
I do.
Okay, and what do you do for a living?
I'm a victim advocate for the Department of Justice, as Judge Rossi has said, for the.
Oh, she's a victim advocate for the Department of Justice. So her daughter has this major stalking incident, and the mom has to protect baby girl. And mom deals with these kinds of creeps every single day, so she knows what they're like.
The United States Attorney's Office for 41 years.
Okay, so you've never had what I'll say a personal relationship, kicked back beers or gone to taverns with the judge?
No, sir. We just had office functions within the office where, and may I say, Judge Rossi was in the civil division and I was in the criminal division, correct, Judge Rossi? Or am I-
Yes, that is absolutely.
So we work in two different divisions.
Oh, okay. So it would be like, working, one floor, or even if you're on the same, but you're in different departments.
Correct. I never worked
Okay.
for Judge Rossi.
Yeah, I just want to establish that for the record.
Great, thank you.
No problem. I'm going to step back into, I don't know if you've had a chance to read these. I assume you have, because we've called you as a witness, but do you know anything about Caitlin's motion and affidavit for a violation of this protection order?
Correct.
And you were present for the conduct?
I was, correct.
Okay, so let's step on each day. Let's start with February 22. Do
Okay,
you remember that, Dave?
that was the Griff's Ice House.
Okay, and that was in 2024?
It was,
All right. And can you tell me about what happened?
yes. Caitlin and I arrived at Griff's Ice House. It was a charity event that we went. We paid our admission to get in. There were players giving autographs at the front. We walked in, and as soon as we walked in, right across the room was Michael Buffum standing across from us. Knowing about a PPO order, I thought that when he saw her, my personal feeling that he should have left, but he stood there, Your Honor. Started pointing at her, talking about her. We could hear him saying Caitlin across the room. Did not leave the room, kept looking at her to the point of Caitlin started to panic. And so we actually made the move to leave that room and go into another room where we couldn't be part of the event that was going on in the lobby.
My theory on that stolen t-shirt from a child is that it was autographed at this event. I may be wrong. That's why I couldn't answer you earlier, Eileen. I have a feeling that it wasn't about having the shirt necessarily, but the fact that it was autographed. And apparently the daughter of this wonderful woman here is a seller and reseller of sports cards and memorabilia. So I don't even think the shirt was for her. Plus, she's an absolute lunatic, in my opinion.
We had to move and wait for the next event, which was inside the ice arena, because we both felt uncomfortable.
Okay, and why do you have feelings of that uncomfortability?
Well, I can tell you I feel uncomfortable because as a victim advocate, I know he has violated PPO orders, this PPO order at least 8 times. I've been with her all these other times that he has violated, been within 6 to 8 feet of her, never leaves, stays exactly where she's at. And so again, this was just another example of him being within within where she was at and wouldn't leave.
How big was this room?
It's not overly large. It's like in the lobby of the Griff's Ice House.
Okay, so but big enough you could be on opposite sides.
We could have been on opposite sides of the room.
I'm going to direct you to exhibit number 1 for
Correct.
petitioner.
Yes,
See, you recognize this individual.
I do. That's Michael Buffum.
And what is he wearing?
Black pants, like warm-up pants, a black jacket, a Griffin's hat. He has glasses on it.
All right, and he's under the what
Men's
sign?
restrooms. Sign.
Okay, and it looks like he's leaning up against a table of some sort.
Correct.
Okay, and where were you at this time?
We were just on the other side of the room. We had just come into the room. He did turn around and look at us several times. And when he saw us getting our phones out to take a picture to show that he was in the same room of her, he turned his head, so I could not get a picture of him.
Okay, did he move around during that time?
He went over to the table where the autographs were and then moved back over by where she was.
Okay.
I mean, where he was originally.
Okay, so at any time he could have been more than 10 feet away if he wanted to be.
Yes, he could have moved further apart or went in the other room where we ended up, again, having to change our lives and what we're doing to Michael Buffum, his behavior.
Okay. What was Caitlin's reaction? I'm thinking on this date, and I want to remind the court again, this is February of. Is it?
February 22nd of 2024.
Okay.
She started to tear up, said, "Mom, he's here. What am I going to do?" I told her that I was there with her, that he should not be in the same room. As we all know, he should have left. She started to have a panic attack. So that's why we left where we were at and went and sat inside the ice arena and just waited for the next event, because I actually don't know, after him trying to run her into the wall on the freeway and the other incidents that I've been with her, of the things he's done to her and said and done to her, that I'm not really sure what he's going to do to her.
Okay, and what forms that belief you're not really sure? I mean, you weren't, let's establish what you were present for. Have you been
Yes.
present for any inappropriate words exchanged?
Yes. I have been it was a couple other instances where we were at Van Andel Arena. There was one.
Objection to relevance, Jenna. I think we need to keep this focused on the event at hand.
Okay.
We're trying to establish, Your Honor, the pattern of conduct or behavior here that establishes the inappropriateness of the conduct on the 22nd. Again, it matters if we have 2 show causes out on the 22nd and the 24th, and we're looking to establish basically, is there a pattern of conduct? If there is, why is there fear for this conduct? And I think that's highly relevant.
Okay, I would agree that there is some relevance as long as the dates are reasonably, close to either the starting of this protective order or the events leading up to the alleged violations. I'll overrule the objection. You may proceed.
Your Honor. So Kathy, I'm going to redirect you. Do you remember the dates that some of the things happened? Can you kind of walk me through that?
Yes, I can actually.
Okay, go ahead.
On November 18th of this year, we were at a Grand Rapids Gold basketball game. Mr. Buffum was there. He came up and stood right behind Caitlin, probably within 3 to 5 feet of her, did not leave. November 15th of 2023, we were in the Griffin store at the Van Andel Arena. Michael Buffum came in there. Caitlin and I were already in there. He was in there with his mother to exchange some tickets. That's what everybody was in there for. He was within 3 to 5 feet of her then, Your Honor, did not move, stood there by her. There was another incident on November 26th of 2023. We were at a season ticket holder event after the game. Mr. Buffum was there with one of his friends. They did not come near us at first, but we walked to the top of the arena to pick up one of Caitlin's friends that needs help to the car. He was then within 3 feet of her. I heard him saying to his friend, Caitlin, he kept saying, Caitlin, Caitlin, to his friend, Charles. He was talking about her then, did not move. After the hearing on December 15th, he was across the ice, staring across from her, gesturing at her and taking pictures of her. December 31st, 2023, I was with her at a Griffins hockey game, the New Year's Eve game. He was standing across the ice, then had all of his friends take pictures of her from across the ice, gesturing at her and laughing. Then we had the Griffin's Ice House event. Then we had I was not there for this auction, but Your Honor, with this auction, they move everybody in the arena into the same section for this auction. So when she wants to attend this auction, she has no choice but to distance herself from him. And that's why they were in the same section for this auction.
So you've been part of auctions in the past.
Oh, yes, I've been to auctions with her in the past.
So you know how they narrow the section.
Yes, they narrow the section all to one. So if Caitlin wants to go and bid on anything, she has to be in the same section. So I've told her, please distance yourself from him, even though he should be leaving because he shouldn't be that close to you, but he chooses not to leave, Your Honor. He stands within close to her.
So you've been present on a lot of.
Oh, this conduct is out of hand, Your Honor.
It's been, so the 22nd is just a long pattern of the consistent behavior.
Yes, sir, Mr. Van Hubel. Long pattern of and then after Judge Rossi, I remember you telling him not to be in what night or not. And Caitlin brings me emails all the time when he's in whatnot after you've asked him not to be in whatnot.
In your understanding of the conduct here, now you had a email, and I'm going to bring that up.
Correct.
That is petitioner's exhibit number 3.
Correct.
Have you seen this email?
I have seen this email. It was sent to me by the Griffins organization.
And how did you come about this?
Matt Bachelor emailed this to me because he wanted to let me know that Michael Buffum's mother was asking about Caitlin.
Okay, so this is yet another contact.
Correct.
Right? All right. And I'm going to ask you, do you believe that this contact has ever quit based on your observations?
No.
But wait. That email that was sent to her, it was sent by someone that works at the Griffin organization. It wasn't the mother of Mr. Buffin sending it to her. It was the mother inquiring something from the organization, and the organization decided to share it with this other woman. So it's hearsay of hearsay of hearsay. I don't see how that's a him problem.
No, it has never stopped, Your Honor, since you first signed this order. It has never stopped. And I guess unless you send him a clear message, it never will stop.
Thank you, Your Honor. That's all the testimony I have.
Very well. Cross-examination, Mr. Hanel.
Yes. So your testimony is, you hear Caitlin, which I think seems to be the same as what her indication was. That's what keeps being overheard coming out of his mouth. Correct?
Yes.
And your testimony is also that this email that she was asking him, his mother was asking about Caitlin, correct?
Correct.
Now, logically, wouldn't it make sense for him to be worried about whether she's going to be someplace so he doesn't have to be there, so he can prepare himself?
No.
So him asking if wouldn't he be better be able to avoid her if he were to ask if she's going to be at Van Andel or not?
No, because even when she is places, Mr. Handel, that she's at, he refuses to leave. So that doesn't make sense that he's checking ahead of time, because if so, he would leave when he saw her, according to the PPO.
Now, no further questions, Your Honor.
Very good. Any redirect, Mr. Van Hubel?
I have none, Your Honor.
Very good. Then thank you, Ms. Schwett. You may step down from
Thank you,
the
Your
witness
Honor.
stand. Any additional witnesses or evidence to present, Mr. Van Hubel?
None, Your Honor. We rest at this time.
Very good. Mr. Hanel, do you have any witnesses or evidence to present?
I think daughter is really blowing this all out of proportion because it's giving her all of this attention from mommy. Mommy is just going crazy over this and coddling the hell out of her. And she's loving every minute of it because mommy's paying so much attention to her right now. Usually mommy's probably really busy with work. But now her baby girl has an instance that relates to her job. And she can give her so much attention over it. I really do. I really feel that this is just the daughter pleading for attention from mommy. Busy, busy mommy.
You're muted, Mr. Handel. You're gonna have to unmute.
Sorry, Your Honor. Yeah, I will call Mr. Buffum.
Very good. Mr. Buffum, would you raise your right hand, please? Do you solemnly swear or affirm that your testimony today will be the truth and nothing but the truth?
That's right.
Very good. You may proceed, Mr. Handel.
Oh, wait, hold on a second. I'm gonna ask you questions. Okay, so I'm gonna refer you to I believe it's Exhibit 1, where I believe this is an auction you're stating for. There's a men's sign in the back.
Yeah, the Sled Wings event on the 22nd of February.
Okay, now it was the sled ring event. Is that what you're saying?
Yeah, the Sled Wings. It's kids that have disabled play the Griffins. They raise money. The players sign autographs, and then they play hockey on sleds for disabled kids to raise money.
Okay, so when you first got there, you didn't see.
And don't forget the part where then full-grown ass adults go and steal children's T-shirts.
Shoot there at all. Is that correct?
Correct.
Did you have any reason to think she was going to be there? Like, did anybody indicate that she was going to be there to you?
No, I just went on me going there and me being a supporter and stuff like that.
Okay, and what happened when she arrived?
When she arrived to the arena or to the event, I was talking with the equipment manager, and he said Caitlin showed up, and then I did not approach her, did not leave the spot where the photo shows, and she was at the door, took a photo of me. So the right thing I did that was the only exit out of there. Waited till they went inside and then left minutes after that.
Okay, so they were between you and the door, is that correct? Okay, so and you left after they got out of the way?
After they went inside the arena.
How long do you think that might have taken?
Within 3 to 5 minutes.
Okay. Now let me refer you to the second violation here. This would be the picture that's in section 121 that was testified about. Were you there first that day?
Yes, that is my season ticket section.
Okay, and it was your understanding of the court order that was where you're supposed to be, right? If something was going on there?
Correct.
Okay, and were there other areas to be for that?
Correct. As she was told, and I was told by Matt Batchel, Griffin's staff members, that the next section over 120 is open for seating also during this auction time.
Okay, so you were in 121 before her, correct?
Mhm.
And she came to that section, correct?
Correct.
And she could have chosen the other section?
Correct. That section 120 was open.
Okay, now, there's been a lot of testimony, I think, in both of these incidences that her name is being said. Like, is that correct?
I have no talking since this all came down. I have not talked with people about it. I'm just there to be a spectator and a fan and enjoy the game.
Now, would it be fair to say you're very concerned if she's going to show up, though? Is that correct?
Right. I'm not trying to break what you've said, Judge, and I followed through.
That's correct. 1 second, I just got to plug in my computer here so it doesn't go dead on us. Sorry, did we cut out there, Your Honor?
Nope, you stayed on successfully, Mr. Handel. You may proceed.
Okay, so it'd be fair to say you're very concerned about whether she shows up somewhere or not.
Right.
And you've been directed to video or to photograph times there might be instances so that something doesn't happen and you'd be able to prove you're
Covering my own back.
Okay, so you're not doing it to threaten or intimidate her, is that
No.
correct? Okay. Did you direct that email to talk about her?
No, I referenced it for my own safety.
Okay. 1 second here. Nothing further, Your Honor.
Very good. Cross-examination, Mr. Van Heuvel.
Thank you, Your Honor. Mr. Buffum, have you read the PPO order in this file?
Yes.
I'm going to take a minute here to share that to you. Can you see what I see here? The PPO order?
Yes, I can see it.
Okay. And it has the judge's signature, correct?
Yes.
Okay. And down here it says it is ordered, correct?
Correct.
Okay. And I'm just going to ask, do you agree that it says do not to follow or appear within the sight of the petitioner? Is that correct? Mr. Buffum, is that correct?
Yes.
And it also says approaching or confronting the petitioner in a public place or on private property. Is that correct?
Correct.
Okay. Would you agree that being within 10 feet of somebody is approaching?
I'm not the one approaching, she's approaching me.
Okay, let me rephrase. Is there an order that petitioner in this file, Caitlin E. Schutte, is she ordered here to not approach?
I have not approached her. I have left when she has come.
And is there an order about who comes first? The answer?
No.
Okay. Do you agree? Let me phrase it this way. I'm going to rephrase that question. On February 22 of 24, you testified you were at the Sledwings Griff's Ice House. Is that correct?
Yes.
And on that date, would you agree? Isn't it correct that you were within 10 feet of the petitioner in this case?
No.
You were not in 10 feet.
No, we were further away.
How far?
One side of the room to the other, as the photo shows. She was at the entrance and I was by the men's bathroom.
On February 2 of 24, were you working for this organization, Griff's Ice House?
No.
So you had no other requirement to be there, correct, sir?
Just as a spectator and a local fan.
That's not what I asked. You had no other requirement to be there, correct?
Correct.
I'm going to direct you to the date of February 24 of 2024. On that date, were you in the arena for a Griffins hockey game?
Correct.
And you were sitting in section 121, is that correct?
Yes.
Were you sitting next to your father when he was taking pictures of the petitioner?
No, it was not.
So I would direct you to Exhibit 2. The set of pictures, the second one of Exhibit 2. That's not you. The second and third pictures, they aren't you, right?
Hold on a second.
Yes or no, Mr. Buffum? Were those you?
Can you show the photos when he's having a hard time pulling them up?
Steve, do you have a copy?
I do. Just give me a second. We've got a lot of papers out here on my desk.
Okay. Let me know when you're ready.
Are you referring to the page where the ice is in the background, or the exhibit where the ice?
Yes. There should be a set of pictures there. Do you have them?
Yeah, yes, they're in front of me.
Okay. So though, just to be clear for the record, that is you.
2 and 3, correct.
Do you have any business purpose being at the arena? Are you hired at the arena?
Can you repeat the
Can you
question?
repeat the question, please?
Are you an employee of the arena?
No,
Okay. You are free. Isn't it correct that you are free to leave at any time?
correct.
I'm going to direct you to petitioner's exhibit, I believe, number 4. It's the what it is the online sports postcard exhibit. Do you have a copy of that?
Yes. Yes,
And the user BUFFUM is you, correct? I didn't hear that.
correct.
Okay. And when you drop into these rooms, isn't it correct that you can see the users there?
Yes,
Okay. Are you an employee of this sports betting or sports buying website?
no,
Are you required to be there for any reason?
I can buy cards.
That's not what I'm asking. Are you required to be there for any reason? And you're free to leave at any time, correct?
Yes,
Did you write several messages on 5/15/24 in 314 sports cards on that platform inside
yes,
Mac Sales? Is that a yes?
yeah.
On that day, was Caitlin Schutte in that sports room?
I don't know if she could be under a different person's name, so I did not see her in that.
Just a moment, Your Honor. Nothing further, Your Honor.
Very good. Any redirect questions, Mr. Hanel?
No, Your Honor.
I do have a couple questions, Mr. Buffum. Remind me, are your season tickets at the Van Andel Arena for the Griffins, are they in 121 or 122?
121.
Okay, and so your testimony today is those photos of you seated at the arena, you're sitting in your season seats, is that right?
Yes, Your Honor.
Okay, so in other words, you don't move between the end of the game and the start of the auction because the auction just happens to be in front of the section that you're already a holder of tickets for.
Correct. And that's not the only section that you can sit in. You can sit in 120 is open for seating also.
Okay, so you could, and you could, for that matter, you could move to 120 or 122, but you'd have to get out of your own season seats and move to those. Okay. All right. And regarding the sports card site, do you have a business yourself trading sports cards and buying and selling them, or is it a hobby for you? What's your affiliation?
I do it for the hobby. I work for the Whitecaps also, so I give back to people and buy cards for them, help them out. I do not sell, just for own hobby.
Okay, for personal reasons, in other words. Okay, and does your family have tickets along with you to the Griffins?
Yes, we have 3 seats, yes.
Okay, so and that would be your mom and dad next to you?
Correct, yeah.
Okay, all right, those are the total of my questions. I'll give you another chance, Mr. Hanel.
No further questions, Your Honor.
And Mr. Van Heuvel.
No further questions, Your Honor.
Okay, very good. Well then, Mr. Buffum, you may step down from the witness stand. Any other witnesses or evidence to present at this time, Mr. Hanel?
No, Your Honor.
All right, then I believe, having both sides rested, we're to the time for a brief closing statement. Obviously, I've heard all the testimony today, and I'm quite familiar with the case. Mr. Van Heuvel.
Thank you, Your Honor. I think the testimony today, Your Honor, demonstrated between Caitlin Schutte and Kathy Schutte that there is quite a pattern here of conduct and contact. It seems to be that there's this idea that just because you're a season holder or you like a hobby that you may be within the violating order range and within eyesight or contact of Ms. Schutte. It's also, there's a misunderstanding, I think, in this trial by the respondent that somehow just because she comes to an event or something, he is somehow absolved of his duty to follow this court's order. And I think that's critical that he be, admonished on that. He is to follow the order whether or not he feels it's fair, and it's against him. It's not against Ms. Schutte, Caitlin in this matter. We heard Kathy Schutte's testimony extensively about the contact that it led to these 2 incidences, and that it was a consistent and continued pattern of conduct and contact. And a lot of these incidents she listed, it sounded like there was ways to avoid the contact, and they just simply don't. The respondent doesn't care. It was what it appears from the amount of contact that's happened here. When we heard from Caitlin, we heard that she is objectionably fearful, that she has physical reactions, that this is inappropriate conduct, and that it needs to stop, and that it doesn't just happen in these 2 events, but it continues on, and including in sports buying areas that she does as a business. And it happens in emails individually to the arena individuals trying to figure out her status and where she's at and what she's doing, which I think is highly inappropriate. Whether or not you want to know or not, it's simply inappropriate to find out, even through a third party that's still directed contact. And so we come to the day of 2/24, and on that day in February, again, the petitioner is up at the top of the arena, not down by the respondent. Respondent's father turns around and starts to take pictures and ask for people to interdict with my client, who then does get contacted. So it's not
I
as
have
if
to hold Mr. Buffum responsible for the actions of his father. I mean, certainly, I guess it would be normal to share with your parents, hey, there's a situation going on, and to some extent to have what I'm going to refer to as a circling of the wagons. The 2 families here logically would probably support their own kids. I mean, is there a chance that Mr. Buffum's father whirls around and does this, whether Mr. Buffum wants him to or not?
After enough of these violation hearings, it should be clear that he is not to have direct contact. This is after, remember, this hearing is happening after we've already had 1 admitted to violation. So this is not a surprise anymore. This is a known factor that we don't have contact. And so if there's continued contact, you can only assume one thing, and that's that Mr. Buffum is not removing himself from the situation, or he's allowing these third parties to act on his behalf. If there's already been a violation, you know the rule. And
he does certainly, but I do note the photos do show, at least it looks to me like Mr. Buffum himself is doing what I would expect. He's looking away and sitting in his seat. Dad, obviously, if Mr. Buffum jumped up and took some photos like he did, it would be a lot clearer than his dad. And I haven't seen his dad at these hearings. I'm making the assumption Of course, the dad knows what's going on, but I also know from my own relationships with my own parents that parents are going to do what parents are going to do. I don't always, we don't always have control or a say over what our parents do, even when it might involve us. So I'm looking for a little more connection there, I guess.
And then, well, and that's why we put in the connection. That is why Kathy testified to the other events that were objected to and it was overruled regarding the consistent pattern that led up to this. She testified very specifically about meeting Mr. Buffum, having him within very short distances, and that he was not moving away. What connects to this event is that when you have this consistent pattern, you may be looking away at this time, but you've had consistent and constant contact. And so at this point, it's no longer an accident. Kathy testified for the 22nd of February that he had turned away. That's when they got the picture, but that he had been facing them. I mean, he just didn't get it on the camera because, of course, they're not chasing him, every minute. Obviously, that's not the intent of a PPO either. And so, that's why it's that context of both before, and then we talk about these emails, which is Exhibit 3 and Exhibit 4 online. We're talking about a consistent pattern. That's why it's established, is because these events are really established by the long-standing pattern that has occurred here. And we would move that he be found in contempt for these, because it is clear he knows, and he's not going to stay away. Thank you, Your Honor.
Okay. All right. Thank you, Mr. Hanel.
Well, Your Honor, first of all, I'd like to object to the use of prior conduct to prove current conduct. And I do believe you could use it to establish knowledge of the PPO. I think that's fair. But the fact that something happened before does not mean this happened now. In these situations, the testimony was she went straight up to him. And I understand the argument that she's the victim and he needs to deal with this. But we have been here before, and we were trying to work it out where they could both be at Van Andel. And, we were all pretty unsure if this was going to work out. We were at the point where she was in her section, he was in his section. That was hopefully going to solve the problem. We're not there yet. But the testimony is he's never said anything to her. He never knew she was going to be in a specific spot. She would enter after he was there each time. And despite her tremendous fear for him, gets within 10 feet of him and puts a camera in his face. And the argument is fair that, yes, this PPO is against him, but it turns out she was between him and the door. You see him there, and she said he just stood in that position. That is the position of somebody that's frozen and does not know what to do. And the fact that she hears her name, there was a testimony
You're referring to the photo at the at the Griff's Ice House under the restroom there?
Yes, correct, Your Honor. And the testimony was that he just stood in that position. And if she's between him and the door, what is he supposed to do? He's scared that he's going to have to get close to her, approach her. Testimony was that he waited till they walked out, and then he left that area. I think he left the entire thing, actually, at that point was the testimony. But now the fact that she hears her name, there was no testimony about additional things that were being said. It makes sense logically that if you're scared about getting in trouble for a PPO, you're constantly on alert that she might be there. You're going to be like, Caitlin's here. That is an issue, and it makes sense that this is a valid concern and a healthy one. It's not that he's slandering her or trying to make anything hard for her, but when you're talking about, is she here? Where is she? How can I avoid her? Her name needs to be said. And that's as good of an explanation as anything they provided in this case.
What about the missing part? Caitlin's here. I got to go in the other room.
What's that?
What about the missing part where he says, Caitlin's here. I got to go in the other room?
Said that?
What are you talking about at the?
Yeah, at the Griff's Ice House thing where you're so close.
When she was by the door and I waited till she went into the main, and that's when I left.
Basically, this, okay. I get this sounds like a nightmare for both of them. We tried to work this out. Ironically, she's not welcome at the Griffins events anymore. So maybe that issue is actually resolved in a way that I think we all didn't expect. We thought
the baseball season's coming right up, Mr. Hanel, so we've got to keep paying attention to the matter.
Well, hopefully we don't. Hopefully this will be over then. But it's possible she may not be allowed there either. I'm not sure about that. We didn't have any testimony about that, but either way, I don't think these are egregious violations. I think, and I can tell you for certain, my advice to my clients in these PPO situations, if you're at someplace and all of a sudden they're there, get your camera out, because we do not know what the testimony is going to be, but we want truthful testimony. And cameras have a way of catching what actually happens. That's not always the case, but in this case, I'm sure that's what the father was doing. Hey, she's here. And thank God he took that picture, because her picture made it look like she was just right by him. But when you turn around and you see the 121, you realize she's exactly where we agreed that he should be. And she comes to him, and it's not him trying to make a mess out of this. I clearly think there's fault on both of them. Unfortunately, for my client, he is the subject of this PPO. But we're here again saying, maybe the issue might be resolved now that she's not going to the Griffiths games, because as far as I can tell, that's where everything happened, except possibly online here. But I don't think we're actually dealing with that today. But it seems like the Griffiths thing is over. I don't think there's much left to do on this. And I really don't think there's an intentional violation here. And I think all the conduct is more nervousness about him trying to follow the court's order.
Okay, well, I have heard the testimony and reviewed the evidence as they have come out today and previously in this case. And of note, I have found a previous violation that I haven't sentenced on yet. With regard to the two violations that are before the court today, I am going to find that the event that occurred at the Griff's Ice House was a violation. Mr. Buffum clearly was very near to Miss Chouette and her mother, and and the idea that while they were between him and the door, he couldn't run out. Well, the photo and the things captured there, they don't look to me like necessarily someone frozen by fear, but rather someone, granted, who doesn't appear to be going anywhere anytime soon. And I couple that with certainly when you're that close to someone, even though, the Chouettes very honestly acknowledged they came in second, they overhear Caitlin's name being at least thrown out there by Mr. Buffum, whose voice they obviously recognize, given the length and the contact that's been engaged in this case. And certainly that would be explainable if Mr. Buffum was saying to the people around him, Caitlin's here, I got to go. And then he exited, moved to the other side of the room, moved as far away as possible. Did something in response to the fact that he's in jeopardy because of this order, but none of that happened. He stood there and ultimately, Caitlin and her mother, decided to exit the situation themselves. Now, obviously, they could have gone into the other room and watched the game. There were two rooms involved here, but it appears that both, wanted to be in the proximity of whatever was happening in kind of what I'm going to refer to as the foyer here with the men's room at Griff's Ice House. And, but again, the onus would have been on Mr. Buffum in that case to get up and relocate himself to a different portion of Griff's Ice House in response to Ms. Chouette's presence. Now, the second incident there at the Van Andel Arena is a little bit different. And the difference is that Mr. Buffum, as he testified today, was in his season ticket seats. After the season ticket seats, he elected to stay focused, as it were, on what was happening at the arena. Now, certainly he's sitting beside his parents, and his parents may or may not, certainly I would hope they would know about the events going on between him and Miss Chouette, so they can help keep their son out of trouble. And Dad clearly stood up and filmed Miss Chouette, but I didn't see any evidence today that was occurring at the behest necessarily of Mr. Buffum, and certainly might be explicable as the reaction of a father saying, well, of course, not a lawyer trying to figure out what's going on here. I'm going to show that Miss Chouette's the one who came closer than she should have rather than my kid. And I don't see any evidence other than, that Mr. Buffum's attention was focused on anything other than the ice arena, the auction or whatever was occurring down on the ice. Likewise, the final violation that was just testified to, that one that allegedly occurred on the Whatnot website. Now, I do clearly remember the website, and I remember my warning that probably the safest course of action is simply to stay off of Whatnot. And in no uncertain terms, obviously, it would violate Michigan's cyberstalking law if Mr. Buffum did communicate directly with Ms. Chouette, or for that matter, through another person, and in one of these rooms said to the seller, hey, I see Chouette's here and I don't like her, or anything like that. That would be an electronic communication that was clearly designed in reality to go to Ms. Chouette. However, I can't say that's true. The interaction I observed there, it looks to me, they are both in the same room. However, Mr. Buffum's doing not even bidding against Miss Chouette. I think that would be ill-advised as well, because it could be construed as vindictive or confrontational, but rather is just simply asking about an item that's up for bid, that they at least Mr. Buffum has an interest in these trading cards, and knows that Miss Chouette has a business, but this isn't her business. And obviously, again, if he were to go into her store and bid or bad talk her store or something like that, that would violate the order. But I can't say that going into someone else's sales area on that same website and simply seeing perhaps, and I know from personal experience, I don't always check when I go to, of course, I'm not involved in sports card bidding, but I do look on Facebook Marketplace for various good deals on types of sporting goods and things of that nature. And I don't always, I don't even know that I could see who's in the room and who's talking on those sites. And so I am, given the lack of intentional communication directed at Ms. Chouette, hesitant to find that would be a violation. However, I have found the prior violation and a violation today. However, I'm somewhat encouraged by the fact that, it looks like since February, it's been limited to this single instance of them both being in the same electronic room. I think that, again, that doesn't rise and without more to the level of violation. I could see ways that it could, but it doesn't appear to have developed to that point. It just seems like they were certainly in the same room, and I'm very hesitant to completely ban Mr. Buffum from the website because, and doing certainly limits his freedom, and also limits the sellers on there. It appears that Mr. Buffum is at least engaged in buying. Obviously, he should not, and is prohibited by the order from any direct contact with Miss Chouette through that. So, given this, and I've said all of these contexts do arise in the context of amateur sports in this card trading platform, not amateur sports. These are professional sports in the Grand Rapids, and I believe also in the Lansing area where these events arose. And it's very clear to me that, both individuals here are, devoted fans of their respective sports teams, and again, tried to craft solutions here that allowed them to live that part of their lives, but not interfere improperly with the other person's rights. And finally, in consideration and coming to a sentencing portion of this, I also take into consideration this did start with a very frightening incident that would make Ms. Chouette, the incident particularly, I'm thinking here, the driving incident, fearful for her life, fearful for life and limb. And after that first traumatic event occurs, of course, the way that trauma works, you don't have to have every time be a life-threatening incident in order to feel that same fear again. Sometimes just being in the presence of the same person will bring up that fear. And that's precisely why we do institute these, and they're personal protective orders. In the criminal context, we call them no contact orders, and they do mean exactly that, that there is no contact when it's avoidable. And I do put these in place with kids that go to the same school at times and neighbors who live directly next to each other. And sometimes the practicalities of life make compliance very challenging. However, it is always incumbent upon the respondent to acknowledge the protective order and to obey the terms of the protective order. And Mr. Buffum has, at least on 2 occasions, violated this order. And as I think I explained earlier, I see 2 scenarios. I see one where, the person says, I'm never going to, no way, have any contact with that person again, and they scrupulously follow it. And then there are other occasions where people say, well, I'm going to treat this like a competition or a game or a feud and see how much I can get away with. And I do sense that on some occasions that's been happening here. Now, on the same token, the person that's protected, another judicial holding about protective orders is that they are a shield against the other person. They're not a sword. They can't be used offensively to corral the other person or to put yourself into the other person's life so that the other person, is forced to, respond defensively because you have the protective order. It's in their interest to do so. And when there's accidental or inadvertent or unexpected contact that comes up, it is still incumbent on Mr. Buffum to respond to that. So in light of those 2 violations that I found, the sentence of the court today will be that Mr. Buffum pay a $500 fine. I will send you the instructions to pay that, and I also have you fingerprinted if I haven't already had you fingerprinted down at the Kent County Sheriff's Department. I encourage people, when you go down, you get to go to the friendly side of the Sheriff's Department, not the intake at the jail side when you get fingerprinted. But take a look around and think long and hard about whether that's the kind of place you'd want to spend 30 days or 60 days or 90 days because of, wanting to play games with a protective order like the one here. Because, I am a strong believer in increasing sanctions in order to change behavior. And that's exactly what the contempt of court statute is designed to do, is to, give the court teeth in changing behavior. And the behavior I want to see here is obviously scrupulous adherence to the protective order as it's in place and remains in place. I believe I saw until December, at least of this year, at which time we would revisit it for an extension. So at this time, I'm going to impose a $500 fine. I'm also aware that out there and unruled upon by me is Miss Chouette's motion for attorney fees. I am currently researching that, and I will rule on that in the near future here, but I haven't come to a final decision yet on the matter of attorney fees. And I would have to conduct another hearing, an evidentiary hearing, to determine the reasonableness of those fees in the event that I find that they are awardable in a case like this. So I'm still under advisement on any attorney's fees. The $500 fine is payable according to my order, and I believe that goes, of all places in Kent County, to the library board, which benefits from it. So anything else we need to place on the record at this time, Mr. Van den Heuvel?
No, Your Honor, only that you will be drafting the order.
Yes, that's correct. Mr. Hanel.
Nothing further, Your Honor. Thank you for your time today.
Very well. I will issue the order, and of course, Mr. Buffum, you should continue as I said, scrupulously observe, and insofar that your parents, whether they're taking your side or whatever their attitude is, tell them, boy, if they're pushing the envelope on here, they're not doing you any favors, because they won't be the ones sitting in the Kent County jail in the event that I find that the violation, is tied to you, but it'll be you doing the time. So, the best advice to them is, even though I know they want to protect you and, be taking photos and stuff like that, I don't think Mr. Hanel's advice is terrible, but I think I would modify it to say, take a video of yourself, what you're doing, and where you're sitting at that time, rather than focusing on the other person, because like I say, these orders are in place to protect the protected individual, and I don't evaluate their actions. What I'm going to evaluate are your actions. So if your dad wants to film that you're sitting in your seat with eyes straight forward throughout the thing, well, that'd be totally appropriate. But I do look askance when the videoing is and you're in jeopardy, frankly, if the videoing is going on and it's focused at Miss Chouette, and understandably, might make her feel uncomfortable, as just about anyone would if they thought that they're being filmed and it shouldn't be happening. So with those cautionary notes, I appreciate both parties' appearance and respectfulness during the proceeding today, and everyone's willingness to engage in the legal process, even though I know it's more drawn out and time consuming than anyone would rather do. It's still much preferable to us, the families engaging in a Hatfield and McCoy type feud where someone winds up physically hurt. I'm grateful that you've both been willing to utilize the legal process. So with that, we're concluded.
Thank you, Judge.
Mr. Hanel, I will mail out the order for fingerprints.
I think he was fingerprinted already, unless we need another one on a different file.
I think he would need to be again for these violations, right, Judge?
Okay.
Each violation. So it probably won't be until Monday or next week. So don't expect to have to go until at least a week from tomorrow.
Oh, okay. Thank you, Lisa.
Okay, thanks.
Huh?
So you have no legal authority nor physical custody of this child. Mom has sole legal and sole physical custody.
Okay. So is this my child?
There was a paternity action that was filed, and you requested DNA.
I didn't reach out to up to Grand Rapids. They contacted me.
Right. Yeah. And they contacted you.
And they told me
they gave you genetic testing, which showed by a 99.99995% chance that you are the father. Then they entered a order. But a child born out of wedlock has only one parent by law in Michigan, and that parent happens to be the mother, because we can always know who mom is. We don't know who dad is. So you are the legal father, but you have no legal custody nor physical custody.
So at what time?
Unless at least if CPS gets involved and Child Protective Services gives you the child because they're in danger with the mother, then you'd have authority. But absent that, you have no legal authority to have this child. As I explained to a mother a couple weeks ago who did not have legal custody nor physical custody of her child because of a prior intervention, you don't have any authority. You got to turn that kid over, because right now, if they follow through, you could be facing kidnapping charges for your child.
Oh, wow. Okay.
Okay.
So
that's how serious this one is.
Okay. Well, I'm a father, and I'm trying.
Well,
Well,
here's the thing.
I'm not trying to argue with you.
Well,
I just want you to hear me out.
Yeah.
I'm not trying to speak bad about
I understood. I'm just trying to let you know where you stand.
Okay. Well, that's fine. You can let me know where I stand. But I'm her father. I want to be able to do. I want to be able to do my part. That's it, sir. That's all I'm asking. My child was born in 2024. Okay, 23, 24. My child is about to be 2 years old next month in April. I seen my child she was freshly born, maybe a week or 2 weeks. I seen her for 2 days. I haven't seen her until February 18th, sir. I caught that bus to come get my baby. Her mom was in distress.
Understood. And at this point in time,
with my part, and
okay,
I have my reasonings, and I have my proof and showings of why I'm okay. That's fine. She could come get her child. I'm not kidnapping nothing, and this is all on record. I could have not answered. I could have not came on Zoom. I could have said. Forget the whole situation and kept going about my day, and then whenever the problem approaches me, it just
let me finish my.
I'm not out for bad. I don't have a job right now. I have a place to stay. I just want to be able to do my part. That's her mother. That's never going to change. I'm not taking the kid from her. I'm not trying to take the kid from her.
If you let me finish,
since you guys going to tell me that child belongs to me too, I would like to have my part too, sir.
If you'd let me finish my explanation, that's where I was going next.
I'm sorry. I'm just
understood.
I'm not that asshole father that doesn't care for the kid. I have more kids besides this one. And for my kid to be left with a whole stranger.
Are you gonna let me finish or not? You're in a situation that I'm trying to extricate you from. Okay. Bottom line.
I just don't want that. I don't want the problems. I'll say whatever I can. I'm sorry. I just feel I just felt attacked on how you just.
No, I thought you needed to. I thought you needed to know what.
That's why it's hard for me to calm down. I'm not trying to.
I thought you ought to know where you stand before you start opening your mouth, and you just keep opening your mouth. Bottom line, this order also gives her custody and gives parenting time by agreement, which she was trying to give you. Then you withheld the child when she asked for the child back. That's why you're in the situation. Yeah, I know why you did. She said, I've got a temporary situation.
I didn't bring my kid back. Let me tell you something, sir. I got to that woman's house. Did you hear the story about Michigan, Pontiac, about the lady who left her
read
kid?
the file. Yes, there was a reason.
You heard about that. I don't think you heard about that. I got to that lady house.
You're not going to let me explain. Then I'm issuing an order to turn the child over.
All I did was go get my baby.
All right.
Now, whatever.
You not letting me explain.
I'm done with it. Just tell her to come get the baby. Because I don't think we go have no type of agreement, man. Because you don't want to hear me out. Because you got the authority to tell me something. You think I'm supposed to just be quiet and not speak my truth and my part? I'm the man. I'm not running from the situation. I want you to do what you can do for me so I can have time with my child. Let me show you my child. I got her a bed. She got clothes. She's got food. She's sleep. She's sleep.
I'm trying to explain to you what to do next, and you won't let me.
She's sleeping. She's not in school.
I was trying. I am trying to.
She has no school on Fridays.
I'm trying to.
My baby's talking.
We're done.
A lot, man.
I'm ordering the child to be turned over, ma'am. If he does not turn the child over, please contact the police.
Yeah, she can come get her. She can come get her.
Well, then she better come get her.
But you're the police. You want me to give you the address where I'm at? You can bring her. I don't care. Y'all can come get the baby.
Sir,
you ain't telling me what I want to hear, man. And I'm not that type of asshole father.
No, but you're being an asshole right now to me. And the problem is I'm trying to explain.
I'm telling you, I want to be here for my child. She wants the child. She could come get the child, man.
I'm trying to explain to you how to proceed beyond this, but you're not letting me talk. So I'm done. Thank you. Turn the child over. Have a good morning. Next time I try to help, please listen. I wanted to tell him how to follow procedures and get the parenting time. All right. There is peace in this moment.
Yes.
All right. Let us go on with the next case.
Okay. Marianne versus Collazo.
Okay. I think I just used a curse word on the record. Oops. I was only quoting him. How's that?
That's true.
Okay.
Oh my gosh, that poor judge. He caught himself after. Yeah. That guy was a bit emotional. Yeah, the bird mug. Just a bit, just a wee bit. Yeah. Oh, I love him. I love him. I've got a little bit more of him, but I think that's gonna wait till tomorrow because it is after 2 a.m. and I am starting to get real sleepy. So, oh, You just wait, come back tomorrow. I got some more. I actually had to stop myself because I kept finding more and more stuff, and I had to physically be like, okay, if you don't go, like, if you don't quit, you're not going to go live until tomorrow. So I had to stop myself because it was just good stuff after good stuff after good stuff. So yeah, tomorrow come back and we'll have more Judge K-Mets. I really like him. Yeah, I've only been live for 3 hours. Only. um yeah, I think he's a referee. He mentioned that he's appointed, not elected. Oh my goodness, thank you for being here. Yeah, and tonight I am not going to accidentally click the button. I had to go in and record myself doing the closing greeting because when I went to set it up to close it, I accidentally hit the confirmation to close it. So you see me just, talking to you guys, and then I'm like, oh, and it ends. Oh, last night was amazing. Tonight was amazing. You guys are what makes it great. You guys are the ones that are funny, and oh, I absolutely love this time. I really do. I love spending this time with you guys. Well, just think, Great Granny, you've got, a good, hour and a half at least, that you can go back and watch still. But I always do encourage people, when you come in late, stay current. Stay with us where we are at, because I want you guys chatting. I want you guys current in the chat room, because then I can post all your comments. Yeah. Stay current and then go back and watch it later. I have 3 minutes until I hit 3 hours. Maybe we'll watch one more. One more.
All right. Okay. Mr. Collazo, did you connect?
Yes, sir.
Wonderful. Welcome. Miss Marion, did you connect?
Can you hear me?
Yes. Good morning,
Okay,
ma'am.
I'm here, yes.
Welcome to
Good
both
morning.
of you. All right. We are here in the matter of Marion versus Collazo, case number 17-09171DS. Now, you've titled this as a motion for custody. What you obviously do not understand is the court orders currently give you custody. You have it. You have sole legal and sole physical custody of this child.
I do?
Yes.
Oh, I understood that.
I realize this case is 8 years old, but yeah, the order from 8 years ago gives you custody. You have custody, but physical custody by court order. You have sole legal custody by statute. Okay.
Okay.
So what you're asking for, technically you already have, but I have a question. The
Yes.
last child support order has him with quite a few overnights. What are those
Yeah.
overnights? Because the file is also bereft of any information as to what the overnights are. The only thing that it states on an overnight, so both of you understand, is that it's by agreement.
Yeah. So that's not working out very well.
What has been happening in the past?
So it's kind of, Kenny would take Kai on Saturdays with his other two kids.
Okay.
And then I don't really have any other form of childcare, and I wasn't. I wanted Kai to be with his family members, so he would go with then Kenny's family or his other child's mothers
How
or
often?
mother. Almost every time I had to work.
Which is how often?
Probably about 2 or 3 nights a week.
2 or 3 nights a week. Do you work evenings or
Mhm.
midnights?
I was working a midnight shift, 7 p.m. to 7:30 a.m.
What do you work currently?
Currently, I'm working days.
Okay.
I work only at night if I can find someone to watch Kai for me.
Okay. Mr. Colazzo, what
Yes, sir.
overnights do you say that you have?
I've had my son every weekend since he was born.
Is that because you work
The whole
weekends,
weekend.
Miss Marion?
That's not true.
I
But
didn't ask if it was true. I'm asking if, well, I guess I did ask if it was true. Sorry. I'm still having after effects from my first motion, which kind of went way off the rails. I'm just trying to get you through this, which is all I try to do most times. So obviously we have a very flexible schedule that's been what it has been. I mean, like I said, this case is 8 years old. What I think you're really needing and what you're really asking for is a specific parenting time
yes.
issue. Like I said, you already have sole legal and sole physical custody. That,
Mhm.
That he would have to file a motion to change that. That's not before me. It's your motion, and technically it already exists. But inherent in this is there's some disagreement as to what parenting time actually is. So and again, the only thing the court file has is that it's by agreement, and you guys have been pretty flexible about that due to work schedules. But
Mhm.
this comes with its own warning. Be careful what you ask for. If you ask for a specific schedule, it's going to be specific. It's not going to be a rotating. Or, it's not going to be, I want Tuesday and Wednesday this week, Wednesday, Thursday that week, and then Friday and Saturday the third week. It's got to be consistent because the child needs consistency.
The child does need consistency. And also, too, I ask that Kenny help with transportation.
Not a
Because
problem.
Kenny lives
Well, and again,
in
though, I'm going to send you to the front of the court to work that out.
Mhm.
Okay. So that you guys can actually sit down with somebody who can help you work through it. The
Mhm.
fees have been waived in your case, so I will send this to the front of the court for parenting time and child support to have it reviewed to make sure it's done appropriately.
Yeah.
Absolutely.
Mr. Colazzo, any questions? It sounds like the two of you have gotten along. It's been haphazard. It's probably been problematic because you guys have been switching things back and forth. Everybody's confused. Let's face it,
Mhm.
you're not together anymore. Your communication ability is probably not all that great. So, but you've done pretty well. I mean, like I said, this is an 8-year-old file and it's very thin, and it seems like you guys have been doing okay up to now. So I
agree.
Either party has the right to ask for specific parenting time at any time during a case when there's none ordered. So I will grant you that request. And then the front of the court will sit down with both of you and try and help you through this. Okay? The good news about the front of the court, as is somebody found out last week during a hearing, front of the court can hear all kinds of things. When you get into court, there are objections to hearsay and things that can be testified to and things that can't be. The front of the court can hear it all. So they're going to sit down and try and work with you. I wish I could on a Friday morning, but I can't undo in 5 to 10 minutes what you guys have been doing for 8 years. After all, I don't know either of your work schedules. The front of the court will need that. That's going to be part of the
Mhm.
thing. They'll also need the child schedule. We need to know when you both are available and when the child's available. And then your most current pay stub so that they can figure out what child support should be in light of what the parenting time actually lands to be. All right.
Okay.
So you'll have your arguments that, because, we try to keep what's the child's used to being what it is. So if you've been having every weekend and you can show that or prove that, that may be a consistency that may be argued for. If she can
Okay.
show no, you haven't, then, that's not consistency. We'll figure out what does work. All right.
All righty.
That's what they're going to try and do for you. All right. So I will send you to the front of the court. Fees are waived in this matter, so it'll be for parenting time and child support because any change in the it's been looks like the last child support order was 2015, so it's been a while. So in other
Yeah.
words, it's time. All right, good luck, and that is inherent in the mother's motion for custody because inherent in that, along with the things that she said in here, are custody, parenting time, and child support because there was support listed, there was kind of consistency issues issued, but the custody issue itself, the big one, that one's already been decided 8 years ago. All right. Good luck, everybody. Because parenting time is what counts. Custody in Michigan is a word.
Yeah.
Physical custody is a word. And I can give her physical custody and give you 300 overnights a year, Mr. Colazzo. So it's parenting time is what matters. Okay.
Yeah, I
So
just need
let's
to be
get
there
that.
for my son.
Yeah. And that's what we need to get. Well, the child has the right to parenting time. So let's give this child their right and let's give them the consistency they need. All right.
Yes, sir.
Thank
And
you.
of course, obviously, daycare is daycare. Whenever you need daycare on your time, that's your responsibility to arrange. And if you arrange it with some of his family members, that's up to you on your time. Okay, but that, sir, wouldn't be considered your parenting time. That would be her parenting
Right.
time, but she's using, yeah.
Correct.
So that's when you are taking care of the child. That's what's gonna, that's what they're gonna want to talk about. All right. So I'll send this to the
Alrighty.
front of the court for parenting time and child support. Good luck to both of you and take care. No offense. May this all work out, and I don't see you again. If not,
Thank you very much.
I'm here if you need me.
Thank
And then,
you.
yeah, well, if there's an objection to the front of the court, what'll happen is then we have a court hearing where I will spend a lot more time with you. Okay.
I just have a quick
Sure.
question. How can I get the information for friend of the court?
They're going to be mailing it to you. Your address is on Drive.
Yes,
They
North
will be
Drive.
they will be sending you a packet and they'll be sending you a request and they'll be contacting you to arrange a time.
Okay, thank you very much.
All righty. Both of you take care. Have a good morning.
Thank you. Bye-bye.
You know, if people would listen, I can try and help.
Yeah.
Yeah, he is one of my favorites, and I don't see him streaming anymore, so that kind of makes me sad. Yeah, they've been managing for 8 years at least by that point, so they were doing pretty darn good. There we go. We get to end on a happy note. I just wanted to include that one because, for one, to get me over the 3-hour hump, and then for two, the reason that I left it in was because the judge got so flustered at one point, and he was like, "Oh, my last hearing." Well, because his last hearing was that ranting and raving lunatic, so that he called an asshole. so I thought that was a funny moment. Well, I don't know about that. It's He gets more time with the child, um, but she doesn't have to pay a babysitter. She gets the benefit of not just the dad, but the dad's family watching the child. I think that's a pretty huge benefit. I don't think enough people appreciate that benefit in a relationship. I think having the family where they want to watch the children, it's invaluable. It's so important for the child. They're building memories with their family, not with some daycare provider, not with someone who really doesn't care about them. I mean, yeah, not all daycare providers are the same, and some really do care about the children that they're watching, but for most, it's a paycheck. And I'm sorry, I don't trust anyone but family with kids. And even then, most abuse and neglect cases happen by family. So, I mean, you really just can't trust anyone. But I really just think, yeah, that's what it boils down to. They need more structure. And unfortunately, the court has to intervene. They weren't able to make it the whole 18 years, but dang, they had a good run. No, yeah. Did she ever? Oh my goodness. All right, guys. Now I'm going to leave and go to bed. Oh, until tomorrow when I come back and we do this all again. Thank you all so much for coming and spending this time with me. I love every one of you. Be safe, be well, sleep sweet, and much love.